Where?
What was that?
No.
No. Okay. All right. Any questions about this law of negligence or any of the duties of either party? We're going to talk a little bit more about the landlord's rights, what their eviction process is. We're going to talk more about what the act says about that next. But any questions about anything we've talked about so far? Okay. So we said that the tenant's eviction remedy is constructive eviction, right? So in a sense, they evict themselves. They make these requests. They wait a reasonable period of time. The landlord either doesn't respond or doesn't address the issue. And after, again, a reasonable amount of time, the tenant can basically just move out. If they move out, they don't have to pay, right? They only pay what they stay. You see how that rhymes? You stay, you pay, you pay, you stay. The landlord has rights as well. So this is not a one-sided street. Remember, your lease is a bilateral contract. And you can show me on your hand, in a bilateral contract, how many sides have to perform? 2, right? Lateral means side. In contract law, lateral means side. So a bilateral contract, a lease, is an example of that, where both parties have duties and obligations to each other. So let's talk a little bit more about the landlord's side. One thing the landlord can't do is something called retaliatory eviction. Now, we saw this on the Q&A. If the tenant complains, or if they exercise their right to get any of these matters addressed, any of these issues addressed, the landlord can't evict them for complaining. This is another one of these things that makes me really sad that this is a thing. I cannot believe that we have to put a law out there that says if a tenant complains, the landlord can't evict them, but here we are. So if the tenant wants to complain to a government agency, maybe they call the local government. The landlord can't kick them out. If the tenant wants to hire an attorney, the landlord can't kick them out. If the tenant wants to call Two Wants to Know, the landlord can't kick them out. That's called retaliatory eviction. And as you can see here, it is prohibited. Another act that we have that's very important in talking about the residential relationship is the North Carolina Tenant Security Deposit Act. Again, this act doesn't care if the landlord has a real estate license or not. Any landlord, any tenant must follow the Tenant Security Deposit Act. So we're going to go through this. Any owner, even if you have, obviously, if you hire an agent, if you bring a property manager on, they're responsible for complying. But it's another one of those acts, again, it doesn't care if you have a license or not. Basic requirements. A security deposit, we need an unneutral place to hold a security deposit, right? We're not spending that money during the tenancy. The point, as we'll learn, of the security deposit is to hold it. If there are no issues at the end of the tenancy, the tenant should get it back. If the landlord needs it to collect past rent or damage to the property, which we'll talk about, then that's why the security deposit is there. And there's some basic requirements. It needs to be in a trust account or an escrow account. Property manager is going to follow the same rules that the rest of us do when it comes to trust account or escrow account. The security deposit can also be held in a bond if the landlord is not licensed. If a landlord or an owner of a property has a real estate license, the bond is not an option. Okay, so if any of you were a property manager before you got your license, you had the option of holding it in a bond or a trust account, but now that you're licensed, the option of the bond is out. Do I have any questions on that? Does that apply to anybody? Do I have any landlords?
Can you repeat that again? I'm sorry.
Yeah, sure. So the security deposit can be held in trust account or escrow account or a bond. The bond is only an option if you do not have a real estate license. If you're licensed, the bond is not an option. It's got to be in a trust account or an escrow account.
But that only is for the deposits, not for like the monthly rent or stuff like that, or
Correct. We're just talking, yeah, our Tenant Security Deposit Act. Yep.
okay.
Yep. Part of the lease or the agreement should be both parties have a right to know where that money is. Remember, it's nobody's money at this point, right? We're not going to decide what to do with the money until the end of the tenancy. So is the tenant going to get it back? Is the landlord going to keep it? We don't know yet. We won't know that until the end of the tenancy. Both parties have a right to know where this money is being held, though. So the landlord needs to notify the tenant of the name and address of the bank that the security deposit's in, or the insurance company that's providing the bond. Again, if the landlord does not have a real estate license. If the security deposit moves in the middle of the tenancy, maybe we move it from this bank to that bank, the landlord just needs to provide written notice to the tenant of where that is, where it's at now. So we're going to keep both parties informed about the location of that money.
I'm sorry, Julie, so if I own a house and I'm renting it, the security deposit has to be in an escrow account or a bond because I have a license, even though it's my own property.
Because you're licensed, you cannot have it in a bond.
Okay.
Because you're now licensed, you can only have a trust account or an escrow, even though it's your own property.
Even though it's my own property.
Because remember, this act doesn't care if you have a real estate license or not.
Okay.
Okay, so, and remember, and thank you, Maria, because remember last weekend we talked about the trust account, and the Real Estate Commission has their trust account course. So if you become a landlord today, you have like 120 days to take that trust account course and make sure that you're handling that trust account in accordance to the North Carolina Real Estate Commission. Everybody good with that? The Tenant Security Deposit Act lists permitted uses for the landlord to keep the security deposit at the end of the tenancy. What are the reasons that the landlord can keep some or all of the security deposit? Well, if we need to fulfill non-payment of rent, if the tenant owes the landlord any money for rent, then we can use some or all security deposit. Damage to the premises, other than ordinary wear and tear. We're going to talk a little bit more about ordinary wear and tear in just a second. And then non-fulfillment of rental period. So if the tenant skips out in the middle of the night, then the landlord has for the remainder, well, until they find a new tenant. The landlord can keep the security deposit if there's any unpaid bills that creates a lien on the property. So what if the tenant doesn't pay a utility bill, for example, and the city puts a lien on the property? The landlord can use the security deposit. If there's any cost to re-enter the property after the tenant's breach, the tenant skips out in the middle of the night, we can use security deposit. Or any cost to remove or store the tenant's property. If for some reason the landlord has to take the tenant to court, they may be able to use a security deposit for court costs. Late fees, remember we said that late fees can be $15 or 5% of monthly rent, whichever is more. So if there's any late fees for late rent, security deposit. And then any filing fees, court appearances. So what if, here's the $1 million question. What if the security deposit isn't enough to cover missed rent, court costs, damage to the property, etc.? The landlord could take the tenant to court to make up for that difference. So the landlord could sue the tenant if there's any outstanding fees.
Can you sue them for like any amount? Like, I mean, I know no one's gonna go trouble themselves for like $25, but is there like a specific amount that they need to owe this person to go?
Not that I know of. Not that I know of. So that the landlord's right to collect. So yeah, if you want to take somebody to court over $25, it doesn't seem like a good use of, hey, $25 is $25, you know, because in the meantime, you could also get the court costs from the tenant. So they would pay the court costs and you'd get your $25 and everybody would be, they'd just be missing time. Get your half a tank of gas if you're, or whatever, depending on the size of your vehicle. My little Hyundai Elantra, $25 will get me half a tank of gas. Some of you out there drive some gas guzzlers, don't you?
I will say that paying to have property removed is not cheap either. I had to do that with a residential client recently. It wasn't a tenant, but I had some buyers buy a property and the seller just left a bunch of stuff and left a bunch of trash, and it was in horrible condition. And I had to pay someone to come remove it and clean the house so that they could move in, and it was not cheap.
Yeah. Yeah, I bet not. I mean, you're basically, did you pay a moving company or did you pay?
No, I paid someone that another agent in my office had used before,
Okay.
A career type person, and it wasn't cheap. I mean,
Right. I mean, it's labor, you know, moving stuff is labor, and you're going to pay for that service. Absolutely. So yeah, and I mean, storage, I mean, dang, if I knew then what I knew now, I would have invested in storage building, at least bought, you know, because people will pay money to store their stuff, right? And we got storage units popping up left and right. Next to Sheets and Dollar Generals, I think you got storage buildings. So I wish I would have invested in that back in the day. But those storage units, isn't this a nice landlord to store the tenant stuff? I don't know. If they're gone, I'd say it's my property now, and what can I get from it on Craigslist or whatever. So yeah, costs involved. And the good news, you know, we said that the laws are heavy to protect the tenant, but the good news is there are some laws out there to protect the landlord. I don't want you guys to think that the landlord has nothing.
I have one, Julie.
Yeah.
When we moved from Florida to here, we rented a place in Winston for 4 years and basically gave the landlord a 30-day notice that we were moving because we were buying. And she kind of just went crazy. Like, she would drive by our house super fast and started like stalking us. And like, she got super crazy. We never saw our deposits or anything. And I mean, we were really good tenants. We took care of the stuff. We took care of the minor repairs, never asked for anything, always on time. And yeah, so we lost out on that one. I didn't realize the protection.
As a tenant, you didn't know your rights, did you? You didn't know your rights to collect your security deposit. And that's, how long ago was this?
This was 12 years ago. It's a done deal.
I fear your statute of limitations has run up. Yeah. Yeah. And I hate to hear that, Sabrina. And that's what I mean by a lot of tenants, I fear, just don't know their rights. She probably said, well, I'm not giving you your security deposit back. And you said, okay, not knowing that,
It was kind of like retaliation because we chose to buy a house first from rent from her.
And you guys were such good tenants. She didn't want to see you go. I mean, you probably were on time every month with your rent. She could bank on that money. Like you said, you were fixing minor repairs. I mean, when my husband and I got married, his landlord was not happy. Everybody else was congratulatory, but I owned and he rented. So, and he was like, I'm moving out. And his landlord did not send congratulations our way. The Tenant Security Deposit Act, if the tenant skips out in the middle of the night, okay, they just vacate the property. I think the common misconception is that the security deposit automatically goes to the landlord. Tenant moved out, they broke the lease, landlord gets it. And that's the common misconception. If the tenant skips out in the middle of the night, the landlord shouldn't wait until the end of the tenancy to try to re-rent the unit. The landlord should get the property ready and get another tenant in there as soon as possible. And what they can collect from the security deposit is that lag time. Like they have to make a diligent effort to get a new tenant in there as soon as possible. So let's say that the tenant skips out with 6 months left on the lease. The landlord should not be sitting on their hands for 6 months, not doing anything, and then taking the tenant to court for 6 months worth of rent. Okay. So it's not an automatic if the tenant leaves. I think that's the common misconception. The landlord should, again, as soon as they find out, all right, let's get this unit fixed, whatever needs to be done, and let's work on getting it re-rented. And they need to get a new tenant in there as soon as possible. Now, they can try to collect, and it may have to be, we go to court, but they can try to collect for that, lag time until we get a new tenant. But they're going to need to show that they worked to get a new tenant in there. Let's talk about what is ordinary wear and tear. First off, let me say this. The landlord cannot keep the security deposit for ordinary wear and tear. What do you guys think are some examples of ordinary wear and tear?
Carpet.
What about the carpet?
Maybe like the track marks just from where the furniture sits and you walk around.
There you go. Do you guys pace on your phone? When I'm on the phone, I pace. And one of these days I'm going to wear a path. I don't know why, but I pace in the same place. So one day I'm bound to wear a path, like you said, where you put furniture. I would consider that ordinary wear and tear. What if the carpet is ripped up? What if the carpet has holes cut in it? Would you consider that ordinary wear and tear? I would think that'd be, if they whip out the box cutter and cut a hole out, I would think that would go above and beyond. So yeah, carpet, where the furniture is, track marks, foot marks, paths, I guess we'll call them. What else? What do you think some other examples of ordinary wear and tear would be?
Handprints on the wall.
Handprints on the wall, smudges.
Smudges and stuff.
What about crayon? Would crayon be considered ordinary wear and tear? Probably not. Crayon's a little bit easier. What about paint the walls a funky color like neon pink? Could that be considered? Probably not, because that's hard to paint over, right? It's the difference in a nail hole to hang a picture versus somebody putting their fist through the wall, right? A nail hole would be ordinary wear and tear. Somebody throwing their fist through the wall or furniture through the wall would not.
So you can have a tenant that goes in, puts nail holes all in the walls, all the rooms, because they're hanging pictures and they're hanging decor. I mean, just crazy. I mean, and this is actual example, because I went when my sister left, and I kept telling her, don't be hanging all this stuff on the wall. Like there's so she went and she patched up everything, and all you see is white patch marks throughout the entire house that you can't do nothing but paint.
And you
Because
know,
they like to hang stuff. That's not ordinary wear and tear.
that
That's
some of that
decorating.
a judge may have to decide on some of this, right? Because I agree, some of these areas can be very gray, and a lot of that could depend. I mean, I got, you know, pictures up right here. When I take these down, I got nail holes, but you also can't tell your tenant not to hang anything on the walls. I mean, what kind of boring life is that to not have to not have anything? So, you know, I agree that there's always you could take the ordinary wear and tear and stretch it, you know, so where does it become excessive? At what point does it become excessive? And that may be where we need to get a, you know, a judge involved. You know, if you have, I love, as a matter of fact, I have it on my hall. I don't know what you guys call it, but like the photo gallery, and you have all the different picture frames and everything, you know, so we have on our hall out here, the photo gallery. I don't know how many nail holes I got out there, but you're right. When I take all those pictures down, I'm going to have a whole bunch of little small nail holes. So at what point does it stop being ordinary wear and tear and it crosses that line to excessive? And that may not be a question that we can answer. That may be something that if we can't decide, then the judge will have to decide for us. So they give us kind of an in general things that are considered ordinary wear and tear, assuming we don't cross that line. So we talked about worn or dirty carpet, faded or cracked paint, dirty windows, walls, frayed curtains or blinds, leaking faucets or toilets, small nail holes, worn lavatory basin, the commode, or burnout range heating elements. You know, you'd like to think that your tenant would call you if the range wasn't working or if the, you know, something was leaking. But this is just part of doing business. Other damage, large holes in walls. I mean, if you're not using the right size nail, now you got a big hole, you use like a big bolt to hang a picture, that's going to leave a bigger hole than a nail. Like I said, you throw a fist or an item through a wall. Broken windows, burnt spots on carpets. I'm in the manual, the top of page 562. It actually says bizarre paint colors. So that takes me back to my hot pink walls.
What did it say about burnt spots in the carpet?
That would be considered excessive.
Okay.
Yeah, because you can't clean it, right? You can't. I mean, the landlord should have, going into this tenancy, they should have, I would think, cleaning and getting it ready for the next tenant is part of their cost. I mean, that's part of the cost of being a landlord, right? Is preparing the unit in between tenants. And the only way to repair burn holes in some cases, I'm thinking like cigarette burn holes or something, is to replace the carpets.
Or iron.
Or an iron. Yep. So, you know, again, unless the lease specifically says things, if the parties can't agree, they may have to have a judge determine for them. And that's where this gets pretty gray pretty fast. The tenant may have one opinion. This could be subjective, right? The tenant may have one opinion and the landlord could have a different opinion. And I mean, this doesn't just apply to landlord or tenant. If the parties don't agree, the judge will decide for them.
How much, what's the maximum amount of tenant deposit you can?
We're getting there. Yep.
Oh, okay.
Yep, we're getting there. Because you're right, there is a max, again, to protect the tenant. With the security deposit at the end of the tenancy, maybe it ends because our lease ends, maybe it ends because the tenant moves out in the middle of the night. However the tenancy ends, the landlord has to account to the tenant. So we have to remember, we told the tenant where the money's going to be during our tenancy. And now that the lease is over, we're going to tell the tenant what happens to that security deposit. So first off, let's all understand that the deposit remains in the trust account or escrow account or the bond for an unlicensed landlord until the end of the tenancy. You can't use that money throughout the course of the tenancy. Remember, that's what a trust account is. It holds somebody else's money. So we're going to keep that money, not use it, not touch it. It just sits there throughout the term of the tenancy. And it, yeah. I hear a question? So at the end of the tenancy, the landlord needs to provide a written account to the tenant about what's going to happen to that deposit. And they have to provide that written account to the tenant within 30 days of the end of the tenancy. If the tenant's not going to get any of it back, the landlord needs to say, this is why I'm keeping some of the security deposit. I got to replace the carpet in one room because you burn it with an iron. You get the rest of it, or I got to keep some of this because you didn't pay me half of last month's rent. Okay, so they're not just keeping it, but they're accounting for why they're keeping it. And if for some reason that final accounting can't be determined within 30 days, then the landlord provides an interim accounting and has to have that final accounting within 60 days of the end of tenancy. So it's almost like an itemized list. This is why you're not getting your security deposit back, all or some of it. So let's say, for example, security deposit is $1,000. I'm just making numbers up. Security deposit is $1,000. And the tenant owes the landlord $400 in unpaid rent. There's no major damage to the property other than ordinary wear and tear, just the cost of doing business. The landlord can only justify keeping that $400. The remainder, the balance, the $600 would go to the tenant. Does that make sense? They can't make up reasons to keep the money. They have to say, this is what you owe me. And this is where we get to get that extra 30 days because maybe we don't have the final accounting yet. I'm thinking like damage to the property. Maybe my carpet guy hasn't come out yet and told me how much it's going to cost to replace that carpet. So I don't have a final number yet. So as we said, the landlord has to deliver the written account. It's going to have an itemized deduction for damages, unpaid rent. Other permissible damages, for example, may include unpaid utilities. If the landlord kept the utilities in their name and the city said, well, they didn't pay last month's power bill, then they can keep that security deposit to pay that. And then it also needs to itemize the balance, the amount to be refunded to the tenant. So you guys hear what I'm saying? Tenant Security Deposit Act, everybody has to follow, Gee, Julie, what's the big deal? Well, if you're the landlord and you don't comply with the Tenant Security Deposit Act, then you don't have the right to retain any of the security deposit after the tenancy. So why do you have to keep it in a trust account or an escrow account or a bond if you're unlicensed? Why do you have to account for it within 30 days? Why can't you touch it throughout the tenancy? Because if you don't comply with the Tenant Security Deposit Act as the landlord, licensed or not, you're not entitled to any of it at the end of the tenancy.
Wait, just for the accounting requirements? So,
with any of his deposit act, yeah, with any of
oh,
them.
okay.
Yep. Again, this goes back to, does the tenant know their rights? You know? And that's why I say that. The tenant doesn't know their rights. I appreciate you sharing that with us, Sabrina. I'm so sorry that you lost out. Don't you hate knowing that you left money on the table somewhere? Dang it.
So I have a question on that. So all right, so let's say I own a house and I'm renting it. I have a license. Is it my duty as, I don't know, licensed professional to notify the tenants, hey, listen, you have some rights, you might be looking at this. Is that something you should do? Or would you get penalized if you don't do that, if you get brought to court, you know what I mean?
I mean, once you're licensed, you're going to be held to a higher standard, right? So to best protect yourself, you may want to share some of these Q&A brochures with your tenant, because once you're licensed, because remember, the commission's job is to protect the public when they're dealing with licensees, when they're working with us. And even though you own the property, it's your own property, bless you. You own the own property, you're still a licensee, right? And you still come into this transaction with more knowledge of the laws and the rules. Does that make sense? So that might be one thing to protect yourself, is to provide them with some of these Q&A brochures, some of these information, or at least point them in the right direction. I mean, with my tenant, we knew my tenant before he became our tenant. And I told him, I said, I have a real estate license. He's like, oh yeah, that's right, I forgot. I said, the only reason I tell you that is because you should feel safer. You should feel more secure knowing that I'm held to a higher standard than if I wasn't licensed. You know what I'm saying? So he, I reminded him, and we talked about, and gosh, for me, I take things for granted. So for example, I started talking about and he's a young man, and I started talking about the HOA, and he's like, what's an HOA? And I'm like, oh, wow, we're going, all right. So he came into this with not much knowledge, not much experience whatsoever. I mean, he's whopping 23, 24 years old, so he moved from mom and dad's house into my condo, right? So there's, absolutely, we're held to a higher standard. Even when we're working in our own personal transactions. But yeah, if you have documentation of actually sending them the Q&As, and you know what I'm saying, that'll just, if you have to stand in front of the commission or the judge, that'll, hey, I'm not going to read it to you, but here you go. I provided you with the information. I think that would definitely sway in your favor.
Well, they say once we become licensed, we're no longer laymen's.
We're no longer the public, are we?
Yeah,
We're no longer the public.
No longer.
We're the very people that the commission is out out protecting the public from. I had a gentleman in pre-licensing once. We were still in person. It was that many years ago. And we briefly touch on some of this stuff in pre-licensing. And he owned and rented several properties. And we got to the section, he was like, something was said about being held to a higher standard. And he was like, really? I mean, are you serious? And of course, everybody laughed because he's a funny guy, and then we went to break, and he came up on me in break, and he was like, am I really going to be held to a high? And I said, I feel like I already know too much. I don't know what you're doing now, but once you get your license, it sounds like it better stop, because yes, you are going to be, I mean, there was genuine concern here. We thought he was joking, but yeah, on the break, he was like, are they really going to see me as dead? I was like, oh dear.
Yeah. In New Jersey, we actually have a brochure that we have to give the tenants.
See, I like that.
It's called Landlord Tenant Rights or Responsibilities.
I like that a whole lot.
Yeah,
now both parties know. Both parties know. Because do you think the unlicensed landlord knows all this stuff?
Mm-mm.
I mean, probably not.
Mm-mm.
But see, now they know that we know. Pre-licensing is required, or post, whatever. So that's the big difference in us and the public, is that we are not. through the eyes of the commission. Somebody asked about maximum limits for security deposit. The answer is, it depends. It depends on the tenancy. If it's a week-to-week tenancy, the max security deposit that you can collect is worth 2 weeks rent. If it's a month-to-month, the max is 1.5 months. And anything greater than month-to-month, the max is 2 months.
Wow. That's
Is
good.
Is that high, low? What's your wow?
Oh, that's high. The 2 months rent maximum. I wish you could do that in Jersey. It's
You don't
only a
get to
month
collect
and-
that much?
Oh, heck no, month and a half.
Really? 1.5 is the
Month
max?
and a half.
Interesting.
Yeah, that's it. And sometimes the work that you have to do on the house is to get it back into a rental, especially if you're renting out homes.
Yeah.
To get it back and you have to paint every time there's a new tenancy.
Oh, geez.
You have to paint, like, and it's so it's 1.5 months rent. And so they tell us, I remember I had to go to landlord tenant court. I was being this is when I was first new. I kept security, and they told me, the judge said to me, when you are a landlord and you rent, you need to take the first 3 months and count that as a what do you call it, like 80% vacancy or a loss or something like that. Like that, you need to have that in your reserve because you're really only going to get about 8 to 7 months worth of profit. So don't even
Wow.
count 3 months of it.
And that's all costs that the landlord, thank you. That's all costs that the landlord should take into consideration when they're, how much rent should I charge? You know, that kind of thing. I mean, it's not just paying the monthly bills, right? It's getting the unit ready to re-rent. It's, you know, there's a lot. So, you know, and to your point, you know, sometimes here, 2 months isn't enough. If you have, you know, unpaid rent and lots of damage, 2 months rent may not even touch it. So again, what's the landlord's recourse? They can take that tenant to court for the balance. If there's any difference, if the tenant owes more, they can take the tenant to court and let the judge hopefully require the tenant to pay those differences.
Not too much. That's nice.
And court costs, attorney's fees, all that good stuff. The Tenant Security Deposit Act, as we said, it does allow the landlord to collect reasonable and non-refundable pet fees. Remember what we said though, the fee is for the privilege of having a pet on the property. If the pet destroys the property other than ordinary wear and tear, then they can come out of security deposit or be part of those court costs if it comes to that. Reasonable, that's really subjective, isn't it? It's just something that the two parties are going to have to come to agreement on. I think what the tenant needs to pay attention to with this is non-refundable. Even if your pet doesn't, nothing, absolutely no damage whatsoever, you're not getting this pet fee back because it's non-refundable. Again, you're not paying for the damage, you're paying for the privilege to have a pet on the property.
Yeah, we started seeing that a lot too. Like, and initially we didn't understand the two, but yeah. So that the privilege is one price and the non-refundable pet fee was for damages. And because most people have pets, they felt that that was unfair. That was two different prices.
Right.
You know, it's a lot of, we have to pay security deposit plus our first month's rent. And now you want us to pay 2 pet costs. So trying to explain that to them can be a little challenging, but they're not happy tenants going in because of the 2 fees.
I mean, they don't have to agree to it. You know what I'm saying? Like they have choices. They can either sign or not. So, but that's, and to your point, I think that's worth the conversation to make sure we're all on the same board with this going into it and not having confusion after the fact saying, well, You know, so what? My dog ate up all the gnawed on all the baseboards. I paid for a pet fee. Well, now it's kind of too late to have that conversation, right? So we need to have that hopefully going into it.
Mhm.
Guys, please keep in mind, service animals are not pets. So if your tenant requires a service animal for their handicap or disability, you cannot charge a pet fee. The service animal is seen as an extension of the person with the handicap or disability. It's no different than them having a cane or a walker. Okay. What if the service animal destroys the property? You can take the security deposit for that. I mean, the kid can destroy it. So, you know, couldn't the animal as well, or the adult could destroy it? Everybody good with that? You can't charge a pet fee for service animals. Late payments. Limits on late payments. If rent is more than 5 days late, then you can have a late payment, either $15 or 5%, whichever is more. If that's monthly rent, excuse me, monthly rent. If rent is weekly, then that fee can't exceed $4 or 5% of weekly rent. And you can only charge one late fee. So on day 6, you charge a late fee. You can't charge it on day 7, day 8, day 9, right? You can only charge one late fee per term, per month, or per week. Does that make sense? So you can't keep adding that on. And again, this is only for late rent. If utilities are involved, there are no late fees. You cannot charge late fees. This is just for late rent.
I have a question.
Yes.
I just thought about something. So what, so which, I guess lease, or lease agreement takes precedent? So with the Section 8 housing, they have like an agreement or a lease, and then you have, and then of course landlords have their lease. And are we going to talk about that?
Not in this class. There is a separate agreement for Section 8 housing. Like you said, the government, the tenants are more protected in that case. So in other words, the landlord needs a really, really good reason to evict them. And because you lost your job and can't pay me rent isn't a good reason, because the landlord can always collect straight from the government. So that's one protection that the landlord has, that if the tenant won't pay, you know, the government will. But there's a lot more. You're right. There's going to be an agreement for the landlord to offer Section 8 housing, and the lease might look a little bit different. So if that's, we touch on that so briefly in pre-license, which I know you didn't get our pre-licensing, but we touch on it very briefly. So that may be something, if that's the route you're going, I would kind of do some research on that. But yeah, we don't get much more into that.
Okay.
Just like I said, better protection for the tenants. If they can't pay rent, then they have protection. But the good news is the landlord does as well. So let's go back to the Real Estate Commission's website, publications. And let's look at another Q&A brochure. And this Q&A brochure is on our tenant security deposit. So again, Maria's point, when you get a new tenant, here's two. You got your tenant security and you got your renting residential real estate. Download the PDF and send it as an email attachment, you know, and then that way, and then keep your sent email. So if it goes down, you can prove to the commission, you can prove to the judge that you provided your tenant with this information to help them better understand their rights. We're not going to go through this one as closely as we did the others, but there's, as you can see, there's a lot of questions. So the Q&A is directed towards the tenant. How much security deposit can a landlord charge? As we said, it depends. If it's a month to month, your deposit can't be more than month and a half. Did I read that right? How much can a landlord charge? And then was rent prior to week to week, 2 weeks rent, month to month,
It's a-
greater than month and a half. There you go. Then greater than month to month. So a year to year is how I'm reading that. If you do a year lease and you can collect 2 months rent. So I just didn't read. Can my landlord charge a pet fee? Yes. In addition to the security deposit, non-refundable pet fee. Pet fee can be any reasonable amount the landlord wishes to charge. If your pet damages the property, the landlord can keep all or a portion of security deposit for that damaged property. What happens to my security deposit while I'm a tenant? Well, to keep it safe, state law requires the landlord to keep it in a trust account. It gives us a little explanation of what a trust account is. And again, as we said, the tenant has the right to know where that is. So we have to notify the tenant. It's in Bank of America. And if we move it throughout the Tennessee, then we need to notify the tenant in writing of the new location. Are there any exceptions to the requirement that my security deposit has to be placed in a trust account? Yes. If the owner is managing their property or the property is being managed by an agent, the owner may post a bond. Has agreed for the owner to hold, the owner may post a bond. I think the trust account is probably the more. Yeah, that's not right. I'm going to argue with this Q&A because once you're licensed or once you have an agent involved, it's got to be in a trust account. So I'm going to argue that point. Can my security deposit be placed in an interest-bearing account? Yes. Basically, as long as you have written permission and the permission of the owner. So could you put a provision in your lease that says a security deposit is going to be in an interest-bearing trust account? Sure. Once the tenant signs that. Doesn't our offer to purchase and contract say that the escrow agent may have it in an interest-bearing trust account? The owner of the trust account would be the one entitled to the interest. And each month they just need to transfer that interest from the trust account to their operating account. Because remember, the trust account is just somebody else's money. So if you are collecting interest, you can't let it sit there. What will happen to my security deposit at the end of my lease term? If you stay for the entire term and have paid all rent, the landlord may deduct only the actual cost of repairing any damage you have done to the property. You cannot be charged for ordinary wear and tear. And the quote, every time you see ordinary wear and tear, it's in quotation marks. That tells me it's completely subjective, isn't it? It very well might come down to something that the judge has to decide if it's ordinary wear and tear. There is no cut. This is the answer for that. Can be determined on a case-by-case basis. You may be charged for unusual wear. So kind of breaks that down. What will happen to my security deposit if I vacate before the end of my lease? In addition to any physical damage, the landlord may also deduct actual damage caused by your moving out of the property before the end of the lease term. They cannot charge you a termination fee or an early termination fee. So again, the landlord has a duty. Turn it around and get it re-rented. Don't sit on it for 6 months and then try to go after the tenant for 6 months or however much worth of rent. So just get somebody back in. What will happen if I can't pay my rent? If you fail to fulfill your obligations, we're going to talk about summary ejectment in just a second. We're going to get you out. And again, we can keep whatever security deposit the landlord's owed for that unpaid rent. Is there a deadline in which the landlord has to return? There's our 30 days after the end of the tenancy. And if they can't account for it 30 days and they do a preliminary, And then they have 60 days, and it's an itemized deduction, itemized costs. This is a good question. What will happen to my security deposit if the ownership of the property that I rent is transferred to someone else? So what happens if the seller sells the lease property, the new buyer, we said, buys honoring the existing lease. And actually the buyer and seller come to an agreement on how they want to have this handled with the security deposit. And they pretty much got one of two choices. They can either, the seller can refund the security deposit to the tenant, the property changes hands, and now the new owner calls the tenant and says, I need a security deposit. So either give the tenant that money and let the new owner deal with it, or, and probably the more common one, is to let the closing attorney assist in transferring it at settlement from the old owner's trust account to the new owner's trust account. If you're buying property that has an existing lease, there's probably going to have to be an assignment done. We're going to talk about an assignment. And the attorney's going to have to be involved anyway to draft up a new lease for the new owner with the exact same terms. So while they're at it, I think this is the more common way, is let the attorney handle. Maybe we do a wire transfer, for example, but let the attorney handle transferring it from the old trust account or the old owner's trust account to the new owner's trust account. So they can help with that transfer. What's that? Questions on tenant security deposits? Let's take a break. 156, come back at like 207, a little bit more about property management. All right. So I was trying to look on break because I really hate conflicting information. You know what? I'm human too. So sometimes I make mistakes. I know, right? So I was trying to look on break. So certainly want to make sure I'm telling you guys right about the licensee thing. And this is what some kind of the challenging thing about law and rule is they change. So the way I've always known it, the way I've always understood it is your trust account, your security deposit, if you're unlicensed, can go in a trust account or an escrow account or a bond. Once you're licensed, then a bond is not an option. So then we just saw something in the Q&A brochure that indicated that may not be the case. So I tried to get to the bottom of it, and I looked at the law and the rule, and the commission rule that addresses this. Y'all want to know what it says? It's commission rule A.107. And guess what? It's been repealed. So I'm not sure. And I'm not going to be able to get back to you guys. So I'm not going to bother Trisha with this on a Saturday, but this is definitely something I'm going to look in because I just want to make sure I'm telling you guys right. You shouldn't worry about it for your test for tomorrow. But now I wonder if that's still the case or if that's something that hasn't updated along the lines. So what I say to you is just another reminder that laws and rules change. So if you are going into the property management or you are going to become a landlord, now that you guys are licensed, make sure you're acting. You would need to investigate this a little bit further, as I am going to as well. I tried. All right, let's see. Okay, landlord. What's the landlord's eviction remedy? If the tenant doesn't pay or if the tenant damages the property, what is the landlord's recourse? Well, the landlord's only legal eviction remedy is called summary ejectment. Summary ejectment means that the landlord has got to take the tenant to court. Remember I told you about my acquaintance that works with a property management company? One day a month, this is what she does. She goes to the courthouse and she files her tenants or her landlords, her owners, summary ejectments for tenants that are delinquent, that need to be evicted. Remember, they can't do retaliatory eviction. We're going to talk about self-help eviction in a second. That's not allowed either. So in the event that the tenant is in breach or they're a holdover after the lease expires, you may know them as a squatter. In the event, in that situation, the landlord takes them to court and has the judge remove them. And if the judge is going to remove the tenant, they're going to send the sheriff. They're going to send the sheriff out to evacuate the tenant. What do you guys think? Do your head one way or another. If you're a property manager, an owner has hired you to manage their rental property, can the broker initiate a summary ejectment? Can the broker do it on behalf of the owner? What do you guys think? Ooh, we're not sure. Remember what we said.
What's the
The
summary?
broker, what was that?
No, I missed the summary ejectment. What is that?
Taking the tenant to court to have them removed. Only the judge can remove the tenant. The landlord, this is the landlord's only legal remedy, the summary ejectment. Okay. Can the broker initiate that summary ejectment? Yes. Why? Because when the owner hires the broker, the Residential Rental Agreement Act says the broker is an extension of the owner. So if that's part of our property management agreement, if that's part of the terms and the duties that they've agreed to, then yes, the property manager can take the tenant to court for summary ejectment on behalf of the owner. Again, the property management agreement has to authorize the broker to do that. It's not an automatic. So the broker is an agent of the owner. They've been employed by the owner. The employment agreement authorizes the broker to do it. And the broker has actual knowledge, which the property manager is the one. Again, they're the middleman, right, between landlord and tenant. They're the ones mediating and having these conversations. So summary ejectment is the landlord's option to get the tenant out. As we said earlier, self-help eviction is not allowed. What do you guys think are some examples of self-help eviction?
Changing the locks.
Changing the locks. When the tenant goes to work, you can't go and show up and change the locks, right? What would be another example? Self-help.
Moving all their stuff out while they're away.
When they go to work, we not only do we change the locks, but we also take all their personal belongings and put them on the front yard. We can't move, we can't touch their personal property, we can't enter the premises, we can't change the locks. I had an instructor once said that her granddaddy sometimes would show up with a shotgun, say, "Get off my property." That's self-help eviction. You can't do that. We can't change the locks. You can't lock the property. As Philip said, you can't remove their property, put it in storage, or put it on the front yard. Once again, we say the only legal remedy of the landlord is summary ejectment. I'm sure we all have stories about landlords that have vacated tenants other ways, but the only legal remedy is summary ejectment. If the landlord wrongfully removes the tenant from the property, then the tenant has a case against the landlord. They could go after the landlord in court. So let's go out of here for just a second. And let's look and learn test pass. A couple forms to look over. Section 4 and 5 is like commercial and property management. So we just kind of lump these all together. There are a few sample forms in here for you guys. We're going to briefly look at them. One would be a very basic residential rental agreement between landlord and tenant. If this form is being used, because it's an NCAR form, so if this form is being used and there is going to be an agent, possibly a firm involved, if the landlord nor the tenant are licensed, then we may have to have an attorney draft a lease up. Maybe if the landlord owns multiple rental properties, they would already have, something drawn up that we can use. Keeping in mind that at any lease under 3 years, we don't even have to have this. So it's just in good practice to have something in writing, of course. But this is the agreement between the landlord and the tenant, as we said. We got the term. The term, when does the lease begin? When does it end? How much is rent per what? Month, week, year, other. Here's our late payment fee. Whichever is greater, not to exceed $15 or 5%. The landlord can collect a return check fee. So if the tenant's check, deposit, or rent bounces, we can collect the max amount being $35 for a return check fee. Security deposit, X amount to be deposited either in the bank or the bank address. This even address summary ejectment fees, complaint filing fees, court appearances, etc. So if we have to go stand in front of a judge, then at least the landlord has this that the tenant signed. The judge is going to absolutely recognize this. Permitted occupants in addition to the tenant. So other than the person that signed this lease, who else is allowed to live there? Now, staying the night is different than moving in. right? So if you're gonna have somebody with a permanent address there and they're not on the lease, then the landlord knows. And you know, there's various reasons for that. For example, what if the property is on a on-site septic system? We know we're allowed 2 human heartbeats per bedroom, right? So if you have a 3-bedroom house, that means that that septic system will support 6 people living there. Now, it's not just bathroom waste, it's dishwasher water, it's washing machine water, right? All water that leaves the house. So if there's more than 6 people that live there, then they're putting the septic system, it's working over capacity, and it could ultimately result in damage to the system if it's working harder than what it needs to. So that might be one example why that's important. Termination renewal of lease. When's it going to end? Are we allowed to renew it? Are we going to do an automatic renewal? We need to agree to that. And it might be, we don't know how we're going to handle that until we're into the tenancy. It might be at the end of the year before we realize you're a good landlord and I'm a good tenant. So let's continue this lease. Let's carry it on. This addresses rent is due when? The first day of the payment period. So rent is usually due the first day of the month. Can't charge a late fee until rent is 5 days or more late. So if rent is due on the 1st, you can't charge that late fee until the 5th. Here's our verbiage about the Tenant Security Deposit Act. So back to our original question, you know, do we need to provide the Q&A brochure to the tenant? Well, if you're using this form or a form similar to it, we're already providing the tenant with this, right? Is the tenant going to read it? You know, I can't make them read it, but at least some of the information. I'm seeing if it said anything. So it talks about the security deposit, what can be used for, tenant's obligations. Our lease is a two-way street. So we talked about the duties of the tenant earlier. Those are spelled out here in the lease. We also have the duties and the obligations of the landlord. So again, that needs to be spelled out in the lease. Make sure everybody's clear who's responsible for what. Utility bills and services, who's responsible for paying for the various bills. I like this a whole lot. Isn't this very clear? You know, landlord and tenant could go through and say, we're going to have the tenant pay, you know, septic, water, electric, gas. We're going to have the tenant pay everything. There is no security system. Maybe the landlord will do the landscaping and the lawn maintenance. But that's pretty clear. You don't have to read much, do you? That's pretty clear about who's going to be responsible for what services. So we come to that as an agreement. Here's our smoke and carbon monoxide alarms. Again, the landlord provides operable detectors at the beginning of the tenancy. The tenant's responsible for maintaining it during the tenancy. So every 6 months, they should be going and changing the batteries. If it's in an association, an HOA, the tenant should know who to contact. Keep in mind, the HOA communicates with the owner. So the HOA is going to communicate with the landlord. So if the tenant breaks the rules, for example, the HOA is calling the landlord. They're not calling the tenant. But the tenant may need to address them for whatever reason. So we're going to provide that information. Right of entry. Again, unless it's spelled out in the lease. Unless it's in a case of an emergency, if a pipe bursts, then the landlord needs to get in to help get that fixed. Pets, addresses pets. We have an additional pet addendum. I have that Learn Test Pass for you guys if you want to look at it. It's under additional forms. There's several property management forms in Learn Test Pass. We're not going to go through those, but they're available to you if you want to look at them. What happens when we terminate? Are there any, does the tenant need to clean? You know, they have to change or cut off utilities. We got to get the name, the utilities back to the landlord's name. So there's various things that the tenant should be responsible for doing. at the end of the lease. Tenant's breach. Our summary ejectment should be in here. Maybe we'll talk about that later. Here's our summary ejectment. There we go. If the landlord has to take the tenant to court to have the judge remove them, summary ejectment, then they can also put the cost of that on the tenant as well. Those court costs that we spelled out earlier in the lease. Landlord's duties, their duties and obligations. Again, the biggest one being providing fit and habitable conditions. If an agent's involved, what their duties and responsibilities are. Again, very basic. Here's like our pet addendum, assistant animal addendum. So if we have a service animal, we got a different addendum for that, maintenance, etc., military status. You know, the other thing too that may need to be addressed that the landlord may want to consider, when the tenant's lease is running out and the landlord knows they're not going to renew, then the landlord needs to work. They want to try to work to get another tenant in as soon as they can, right? Because if they don't have anybody paying rent, but they're not making any money. So how is the tenant going to cooperate for any showings, for example, to show the property for the next tenant? Have you guys, let's go back to residential sales for a second. Have you guys shown a tenant occupied property yet? They really don't like us coming
The
in, do
worst
they?
showings.
What was that,
worst.
Nabila? What
I
was
said
that?
the worst showings. It's just not.
They don't like us, do they?
Not
When
at
you
all.
show up with your buyers, tenants are not happy to see us. So, you know, just kind of be prepared for that. Prepare your buyers for that. I showed property once on a Sunday morning. It was like 9:30, 10 o'clock on a Sunday morning. When we walked in the front door and there were smells in that house that reminded me of my college days. And I'm like, yo, it's 10 o'clock on a Sunday morning. I'm like, I hear you. My buyers walked in and turned around and said, no, we're not. They were just totally put off by that. And I shared that in the feedback. And I'm like, look, if the tenants have to be there, maybe they're not engaged in their extracurricular activities until after we leave at 10 o'clock on a Sunday morning. Like, that's how you do it, I guess. I don't know. All sorts of things can happen. So again, a very basic lease, residential rental contract. This is going to be one of those that, you know, it's just so basic that it may not apply. And when landlord and tenant start, and especially when the agent's involved, we still can't, even in the property manager, we still can't draft legally binding documents. So if terms start coming up, trying to agree to terms that aren't covered in this form, then we may just have to get an attorney involved. The other one I want to look at real quick is our property management agreement. And the reason why I want to look at this, because I just want to make sure you're probably going to talk more about this in 301 if you haven't taken it already. And the reason you're going to talk more about this in 301 is because this is our agency agreement. This is the form that creates the relationship between the owner and the property manager. And this is what gives the property manager the authority to act as a property manager. The agency agreements, remember, are our employment contracts. So the owner's hiring us to do a very specific job, in this case, manage their property. And the extent of the authority of the property manager needs to be spelled out in this. Remember, the property manager has some decision-making authority. They have some ability to make decisions on behalf of the owner. Think about it. If you, let's pretend you're not licensed for a second. and you hire me as a property manager, and I have to call you every day. This is broke. Can I fix it? This isn't work. Can I do so? The tenant didn't pay rent. What should I do? If I have to call you every single day over every single thing, at some point you're going to question, why are you paying me? Right? Why are you paying me to do this job when I don't have any authority? So the authority that the property manager has is much greater than that of the sales agent. The sales agent has zero authority, zero ability to bind. The property manager can. The agency agreement, the property management agreement, has all the same rules as our other agency agreements. It has to be in writing. We have to have a definite end date. We have our non-discrimination clause in here. And we have to have our license number on it. But probably one big exception to this form and our sales agency forms is that this agency relationship allows for an automatic renewal. So while we do have a definite end date, we may agree to automatically renew it. Ideally, the property manager and the owner are creating a long-term relationship, right? The owner doesn't want to change property managers every other year or whatever. Hopefully we're creating a long-term relationship. So if we give it a trial run for a year and we're good with the year, you're happy with the way I'm managing your property and I'm happy because you're paying me, then we can agree to automatic renew. And that's the big difference between this agency agreement and our buyer agency and our listing agency agreements. The other thing I want to make sure that we understand, this is an agreement to manage the property. What if the owner decides to sell? Does this form give me the exclusive right to sell their property? No, it just gives me the right to manage. So if I've been managing it for 3 years and all of a sudden the owner decides to sell, we need to enter into a different listing or different agency agreement, don't we? We need to get the listing agreement so I have the ability to sell. I think it's so important that we remember our agency agreements are for a very specific thing. In this case, I'm only being hired to manage your property, not sell it. Questions on that, comments?
Can I ask a quick question? Can you
Please.
enter in an agreement as a, professional to have like to have the property manager in agreement and also to sell if they're looking to go that route? Can you be in both agreements?
I mean, yeah, it'd be either for rent or for sale. Here in Winston, I know there are a handful of firms that do both for sale and for rent. So, and I mean, particularly here in Winston, we got a property manager. And if you guys are members, wherever you are, I'm sure there's some kind of closed Facebook group, with other realtors, other agents. And in ours here in the Triad, one property manager will pop up every once in a while and say, another owner has just released 20 properties for sale. And so then they'll kind of give you, so they're done in the rental game, right? And now they're ready to sell. And because his firm does both, that's the key there. Does your firm offer for sale and for rent? Okay, so generally if you're for rent then for sale, but like my sales firm, we don't do for rent. So I would just have to refer it to a property manager, but that may come down to firm policy as well. One thing that this addresses, again, something different that this addresses is duties upon termination. You got to think for the last 5 years, the property manager has been managing the books and the records and all the information about this property. And now they're not going to be doing it anymore. So part of our duties of termination is to make sure that we get all those records and reports either back to the owner or over to the new property manager. And the property manager's duties may not end on the termination date, because for the last 5 years, the tenant has been calling this property manager. So they may not know right away that it's changed hands, that somebody else has taken it over. So they may not know just yet where to send rent now. So the old property manager is going to have to kind of, keep sending stuff to where it needs to go after they're no longer the property manager. They can't just drop it. They need to help make that a smooth transition. Again, either until the owner takes it over or the new property manager. Yep, there's our non-discrimination clause. And then anything, guys, anything we sign, we're going to have our individual license number. So if you guys don't have that memorized yet, go ahead, go and memorize it, because everything we do. Questions?
Self-help ejection.
Yeah.
Eviction.
Okay. Another form of property management could be in the act of a vacation rental. So those property managers, any owner of a vacation rental property has to abide by the North Carolina Vacation Rental Act. The Vacation Rental Act is fine-tuned from the Residential Rental Agreement Act. So a lot of the terms that we see in the Residential Rental Agreement Act, we're going to see in the Vacation Rental Act as well. It's just for a shorter period of time. It might just be for 1 week as opposed to a year, for example. The Vacation Rental Act does not apply to hotels or motels, for example. It's just vacation properties, properties rented for recreation. And again, everybody has to abide by the North Carolina Vacation Rental Act, whether or not you have a license or not. So if you're an unlicensed owner of a property at the beach, for example, you follow the VRA, we're going to call it. So the rental of residential property for vacation, leisure, or recreation. Note that does not say business. So it's for vacation, anything fewer than 90 days. And the tenant in this case has a permanent residence somewhere else. Most of us that are here in Winston, I mean, we're not going to deal with this. You know what I'm saying? Winston's great, but people don't vacation here. You get down to the coast, you get up to the mountains, you may find yourself affiliating with a firm that does have the Vacation Rental Act. As we said, it doesn't apply to hotels or motels, as long as it's for vacation or recreational activities. VRA, Vacation Rental Act. In order for a vacation rental agreement to be valid, this one has to be in writing, regardless of the term, even if it's for a day. It's got to be in writing. There's a special notice, required provisions. We're going to go look at those. Make sure we're good on that. So if we go back out to our digital manual, and this is the Vacation Rental Act. So there's this special notice that's required in the vacation rental agreement, and it's here for you guys. And basically that special notice says, here it is all in caps. This is a vacation rental agreement under the North Carolina Vacation Rental Act. The rights and obligations of the parties are defined by law and include unique provisions permitting the disbursement of rent prior to tenancy and expedited eviction of tenants. Your signature on this agreement or payment of money or taking possession is evidence of your accepting of this agreement and your intent to use the property for vacation rental. So that's kind of one big exception with this form, this act, is you can collect rent, you can collect payment before tenancy occurs. So as you guys know, if you want the house at the beach, for example, for a week, you're generally paying that before you ever get there. We'll talk a little bit more about expedited evictions. And then the provisions that we just mentioned, again, are listed here. So the rental agreement, vacation rental agreement, needs to contain how the funds are going to be received, deposited, and dispersed. By the way, if you're in the hard book, I'm on page 575 and 576. Sorry about that, 575, 576. Processing or administrating fees that are allowed under the Vacation Rental Act, cleaning fees. There's those duties and obligations to landlord and tenant. It's still a bilateral contract, it's still a two-way street. There's that expedited eviction procedure that we'll talk a little bit more about that. Rights of the landlord if the tenant if the property is transferred. So if the vacation home is sold. These are kind of the required provisions. Mandatory evacuation, we'll talk about that in a second too. Hurricanes hit the beach sometimes, so there's got to be provisions in that Vacation Rental Act for that. And then any other obligation of the landlord or tenant. So special provisions and special notice that we were referring to. The enforceability, tenant accepts the agreement. They either sign it, as we said, we just saw in our special notice. The tenant either signs the agreement, they pay their monies, they pay their receipts, or just by taking possession. Either of these are going to constitute acceptance of the terms of the tenant. Again, hopefully they're reading it before they sign or show up for vacation. NCAR does have a form for us, the sample form to use, vacation rental agreement. This is also a learn, test, pass. We're not going to go over it. But for my, let's see, I got somebody in Mount Airy, I got somebody down in Jacksonville. I don't know how much vacation you guys deal with, but you know, you got a better chance of dealing with it than what we do here in Winston. So you very well may come into counter with that.
The leaves are big up here, so there's
Oh yes, leave season.
Airbnbs up in like Galax and stuff.
Yes,
And Cana for the leaves.
yes. Mayberry days. Do you get a lot of vacationers for Mayberry days? That's a good time.
And I'm in the loop, the wine loop. So yeah.
You get the wine tour.
Oh yes.
Yes.
Heavy wine.
Yep. So here's something that's really unique about this form. This is the only form, let me rephrase that. This is the only NCAR form, North Carolina Association of Realtors, that a non-licensed owner is allowed to use. So if the owner of a vacation property and they don't have a license, they are permitted to use NCAR's form. How about that? The only brokers that can use this form are those that are realtors, those that are members of the National Association of Realtors. So if you're a non-realtor member, you cannot use this form. as the case with any of our NCAR forms. Again, the exception to this is the owner. How about that? Any deposits, down payments, fees, etc., need to go in a trust account, escrow account. Bonds are not allowed. Licensed or unlicensed. So if you're handling if you're property management of a vacation property or probably several, even if you're what would they call it, a VRBO, vacation rental by owner, VRBO. Don't you love real estate? If we can make an acronym out of it, we're going to. So there are no bonds, trust account. Dispersing of the monies prior to tenancy, any administrative fee for the cost of processing the tenant's reservation. Any fees owed to third parties and up to 50% of the rents received. That money can be dispersed prior to tenancy. Dispersed from the trust account to the operating account of the property manager. Usually when you put down a down payment for vacation property, it's going to be non-refundable in very rare circumstances. We're going to talk about one of those in just a second. If the owner of a home that's been used for vacation properties sells the property, the new owner needs to honor any existing rental agreements within the next 180 days. So you buy a vacation property, you have to honor those rental agreements within the first 6 months. You can honor anything after 180 days, but if you choose not to, then those tenants over 180 days are entitled to a full refund. So just like with our tenants, we have to give them 90 days, for example, in a vacation property. If you sell, then we just need to honor any commitments. But if you're going to buy it as a vacation property, you already got rental agreements for the next year, you're good. Again, when we transfer property, when we sell to a new owner, any advance payments, advance deposits, fees, all of that needs to be transferred to the new owner within 30 days of closing. This is going to be for all tenancies that happen after closing, of course. So again, any deposits, fees, down payments, transfer them to the new owner so they have them for their tenancy now. We mentioned this expedited, expedited eviction. If you have a holdover or a squatter in a vacation property, maybe they're supposed to leave Saturday morning by 10 and they don't. The landlord has to give them 4 hours notice to leave the property. This notice can be oral, it can be in writing. Writing obviously stands up better in a court of law. You can post something on the door. You're a holdover 4 hours after they're supposed to leave. If after that notice has been posted, the tenant still doesn't leave, then the landlord has the right to initiate illegal proceedings. And in some cases, that can happen if the judge, whenever you can get in front of a judge, to me, that would be the challenge. When can you get in front of a judge? But once you get in front of that judge, then the judge can rule the tenant out 12 to 18 hours after the hearing. So, I mean, again, let's think about the beach. Most vacation rentals that I know, the beach usually go Saturday to Saturday, right? There's some exceptions. I don't know if a judge is going to be around on a Saturday. So it might be Monday before you can get in front of a judge, if you're lucky, for this expedited eviction. But as with the residential property or residential landlord owner, they can't change the locks. They can't remove their personal belongings, right? They can't self-help eviction. So they go in front of a judge. If the magistrate finds in favor of the landlord, then they could have the tenants removed in 2 to 8 hours. Again, I would say it depends. It's a Saturday or Sunday, you got to get in front of a judge first. But they could allow, that's that expedited, I keep saying that, expedited eviction, 2 to 8 hours from the judge's, the tenant would have to vacate before the judge sent the sheriff. I never thought about those problems with vacation properties, but I'm sure they happen. You got the tenant that's having so much fun at the beach, they don't want to leave. The duties to the landlord and the tenant are similar of our Residential Rental Agreement Act. Those provisions are the same. And again, as the same with the Residential Rental Agreement Act, the landlord can't try to slip language in there. The TSD is the Tenant Security Deposit. So the Tenant Security Deposit Act still applies those rules. Landlord has to provide fit and habitable conditions. Tenant owes money. If there's a security deposit, it can only be used for actual damages to the property. I think a lot of landlords in a vacation rental situation are requiring payment before you ever get there. So we don't have to worry about collecting rent as much in this case, but we do still have to worry about damage to the property. So there might be a deposit. Read the fine print, because with vacation properties, there may even be a non-refundable deposit. So make sure you read that fine print. With vacation properties, you may run into mandatory evacuation. The tenant has to comply with any mandatory evacuations. So if a hurricane's coming, and they evacuate the island or the coast, that portion of the coast, the tenant's gonna be entitled to prorated refund. So if they only get to stay 2 out of their 7 days, for example, they could be entitled to a prorated refund, unless the tenant refuses vacation insurance or the tenant purchases another type of protection insurance by the landlord. But the tenant should never be feel that they have to stay when a mandatory evacuation comes up. And that, again, that should be a term in the lease. So read that fine print. What's our hurricane season? June till October. So, you know, beach season. So let's look. Go back to learn, test, pass just for a second. This additional forms has most of the forms we're talking about, but here's our Vacation Rental Act. We just saw kind of a little print version. Again, Residential Rental Agreement Act is going to apply. It's just for a shorter term. It's going to be for a smaller. So how the money is going to be dispersed, here's our security deposit, how that needs to be handled, any processing fees. Where's our fees? Back up here. Advanced rent, rent balance, reserve fee. How is that fee broken down? Have you guys rented a house at the beach lately? I mean, sometimes they require 50% just to reserve that week. And then they want the remainder due. Trust account guidelines, occupancy limits, if there's an agent involved. Can they cancel? Are they entitled to a refund? What happens if we sell? Here's our 180 days. If the vacation property is sold, the tenant knows that as long as they're with 180 days in, mandatory evacuation, expedited eviction, are pets allowed, etc. So this is a much smaller version. And again, what makes this form unique is that a non-licensed owner can use this. Again, if you guys are so inclined, in the additional forms, back to our Residential Rental Agreement Act, here's that non-refundable pet addendum that addresses that. Is there assistance, animal, a service animal involved? So again, just more FYI stuff. Nabila, we know you have a rental property. I have a rental property. So to me, no, because nobody seems interested in going to property management. So to me, this would be just more of a personal, if you're ever going into that rental, becoming a landlord. It's a tough decision to make. I'll be honest with you guys, when we bought the house and then the question came up, what do we do with the condo? I was so on board with selling it. I was so ready to get rid of it, but husband said, let's just give it a try and see what happens. And we're coming up on 1.5 years now with a really good tenant. So I'm glad we rented. Just depends on what the next tenant is going to look like, right? How that's going to look. But it's nice to know we have options. Questions, comments, vacation rental properties. We went to the Outer Banks. It was like last fall, early, maybe around November or something like that. And we were out to dinner and we were talking to a lady that lives at the Outer Banks. And she was saying there were some homes at the Outer Banks that had reservations throughout the next 5 years. So there are some homes that if you want to rent at the Outer Banks, you're reserving that for a week, 6 years from now. You believe that? I mean, you know, that's the rental market is huge. So I think, and you guys have seen some of those homes, right? I mean, you can get 20 people in a house. Those things are huge. So the vacation rental business is booming for sure. We just went to the beach last May and there were 9 of us. We got a big old house. The house is bigger than we had the people. So I think we're going to invite more next year. We're going to fill it up. And then that's less I have to pay, right? So that works out too. Questions or comments? Vacation rental? Okay. All right. Let's take a break. Let's see, 2:58. Let's go till 3:10. Take a few extra minutes. Stretch, go outside.
Get coffee. Oh my goodness.
I hear you. Coffee at 3 o'clock. I would never sleep tonight.
No, I'm about to. I don't know what's going on today. I'm sleepy.
this is probably because stuff that we don't deal with every day. So this probably isn't the most exciting part of it. I get that.
Yeah, I've been fine throughout the other two classes and even last week, but today, Julie is, I don't know. It's just- I'm gonna get some coffee.
There you go. There you go. Okay.
All right, see you in a few.
All right. we just had something interesting happen. My husband saw a baby deer in our garden, and he went out to run it out, and it came up to him. Like he wasn't scared by it. And it concerns me when wildlife is not threatened by people, you know? I'm like,
Fawns-
where's mama?
Fawns typically won't be.
Really?
Yeah,
That's
typically
gonna
you
be-
can walk up to a fawn now. If you walk up to a fawn and mama's nearby, you might get a little bucked, but
Right, but where's mama now? I mean, you know, and we have neighbors behind us, and they have two young girls, and they said deers come right up to them. And the neighbor said, one of our other neighbors, I guess it's living underneath her deck. I'm like, I wonder if she knows she's got a fawn living under her deck.
I have a coworker that lives in Greensboro. I'm not quite sure where, but she lives on one of the lakes out there.
Uh-huh.
And she's got a ton of wildlife. So she actually feeds all the deers and gives them apples all the time. And like, they aren't afraid of her one bit, walks right up to her all the time. But it's kind of scary because it's wildlife and they need wildlife
What
nature.
happens if something happens to her? Now they don't know how to get food. You know, I mean, that's the problem with,
Mhm.
I think that's one of the problems with messing with wildlife is we condition them.
Mhm.
And this deer has been to, you know, husband, neighbors, you know, she's just making her way around the neighborhood apparently. But yeah, I'm like, is that thing eating my cucumbers? You know, he said probably. So I need to figure out how to keep it out of my garden. But now there's, you know, bear sightings here in the Triad. Have you guys been following this? And you can kind of watch the path of bears in High Point last week. As a matter of fact, my husband lives out, if you're in High Point and familiar with the Palladium area, my husband works near the Palladium, and one of his coworkers was coming back from lunch, and the bear crossed the road on Eastchester, which is a, you know, 4 or 5 lane highway. So that's concerning too. I mean, I understand they need somewhere to go. Absolutely. And that's part of us developing, is we're chasing them out of their natural habitat. He's probably just looking for somewhere else to go. And I get that, but not all people, I think people mean well in most cases, but people don't always do right by animals because they don't know. They think they're helping. But I'm with you, Sabrina. You mess with wildlife and sometimes you're hurting them, you're harming them. So I'm open to how to keep deer out of your garden, natural remedies. If anybody can help me out, I need to know this apparently soon.
A really, really tall fence.
Uh-huh. Anything else? Dang, but yeah, he's got video, and he walked outside, thought he flung the door open and thought it would spook it, and he walked right up to it, and she just stood there, and you know, just happy she could be to see him coming. So, oh my gosh. All right. Vacation Rental Agreement Act. Again, I think the big thing, you know, awfully similar to the Residential Rental Agreement Act. It's just for a shorter term. And you may have other things that come up like expedited eviction, mandatory evacuation, that kind of thing. Let's switch gears again, one more time. I'm still in this section. Property management. We need to talk in property management about how rent gets paid. So maybe this is residential, maybe this is commercial. This point of the conversation could apply to both. But there's different verbiages, different, I guess I should say, types of lease for which can allow the landlord to get paid. And again, anything is going to be by agreement. So before we go into this, we need to understand the terminology. We've been talking about landlord tenant, right? When we talk about landlord tenant, we're primarily talking about the residential unit, okay? When you start talking about the commercial unit, your verbiage changes a little bit. We don't say so much landlord and tenant. In commercials, we do lessor and lessee. So in commercial transaction, the lessor is going to be equivalent to the landlord in residential. The lessee is going to be equivalent to the tenant in residential. Both can be used interchangeably. Lessor, landlord, lessee, tenant. And we're in the manual, we're skipping around in your manual just a bit. So if you're following along in the hard book, we're back to chapter 19, which is our commercial unit. Specifically, we're picking up on page 718. And talking about the different types of leases. The first type of lease we have is a fixed amount, the fixed rental, also known as the flat lease. And this is a fixed amount of rent at regular intervals. This is more common in the residential rental, but you can have it in commercial rental as well. So some examples might say you can rent this apartment for 1 year at $700 per month. That's fixed. Everything's included. Well, not everything. Property maintenance, for example. Utilities may be separate. In the commercial world, you could also have a fixed rental, but the verbiage could be a little bit different. You can rent the office space for $75 per square foot for 5 years. It's fixed. It's this amount every month for the term of the lease. As we said, this type of lease is most common in residential, but you can also come across it in some commercial leases for sure. So fixed rental. Another type of lease that we have that we're primarily going to see in commercial is called the percentage lease. With the percentage lease, this is quite often what we see in retail leases. So all or part of the rent is going to be based off of the percentage of the tenant's sales. Maybe they're gross sales, maybe they're net sales. Usually we do gross sales because the definition of gross sales tends to be more clearer than that of net sales. So if we say gross sales, we have less room for misinterpretation. But again, whatever the parties agree to. And a common percentage lease would say, I'm going to charge you X amount per month for your base rent, plus a percentage of gross sales. And we're going to look at an example on the next slide. So rent would be, would consist of two parts. A flat amount base rent, this usually on the percentage or square foot, excuse me, the square foot of the space that you're renting. And then a second piece that would be percentage of sales, most commonly, more commonly gross sales. So while you guys don't have to do math for your test, for those of you that know me that know, I just can't stand not doing math. So if we can look at a math example together, this is what I don't like about this class is there is no math. So if we have, for example, you have a monthly base rent that's $700 per month. And the lease states that in addition to the base rent, the leasee will pay 5% on the gross sales on anything over $250,000. So the lease says you don't owe me a percentage until your gross sales go over 250. Last year's sales for this company were $315,000. So if we were asked if, and again, you're not going to for your test, but sometimes seeing the problem helps us get a better understanding. What is the leasee's annual rent? So we know first off they have a base rent of 700. Let me change that, hang on. They have a base rent of $700 per month, which would give them, and you're getting ready to see this, it would give them an annual base rent of $8,400. That's one piece of it, right? Regardless if you have any sales this year or not, at a minimum, you're going to owe $8,400. And again, that's usually per square footage. I mean, think about, let's go back to the mall. Think about the difference in square footage from Claire's versus like Belk or JC Penney, right? Claire's is going to have a much smaller base rent because they had much smaller square footage. Then the second portion of the rent is paid based on the percentage of last year's sales. So it says anything over $250. So if last year's sales were $350,000 and anything over that, then the first thing to do would be to find the difference. You're getting ready to see it.
Oh, okay.
I can't do a dark color because then you don't see it on the black, but then I need to do it on the light. You can't see it while I'm typing. So, yep. So you have 315 were last year's sales. So how much is over the stipulated in the lease of 250,000? There's $65,000. Everybody good with that? How we got the 65? What's over the difference in the 315 and the 250? And then the lease says we're going to pay 5% on that overage. So our 65,000 times 5% is going to give us an additional 3,250. So each year for this year, each year you're collecting the base rent of 8,400 plus the percentage, which means the annual rent this year for that tenant would be 11,650. Divide by 12 to get your monthly rent. Next year, your rent could be different. The base rent could stay the same, but if your sales change next year, then your percentage is going to change, and then that's going to affect your annual rent. And again, that's just a real quick breakdown on how that percentage lease may look. Questions on that? Okay. Another type of lease that we may see, another way that rent can get paid, is something called a net lease. And a net lease, again, can be found in commercial properties. But in a net lease, the leasee or the tenant pays rent plus some or all of the property expenses and costs. Examples of things that could be property expenses and costs: repairs and maintenance, maybe janitorial fees, property taxes. The landlord could negotiate to have the tenant, the lessor could have the lessee pay property taxes, maybe even property insurance. So in addition to paying rent, the lessee is responsible for the property expenses. And again, mostly in commercial, but specifically, we tend to see this in long-term industrial leases. So the net lease. Another type of lease we have is the graduated lease. As the name implies, the rent grows at regular intervals throughout the lease. Maybe we have predetermined dates that the rent goes up. With the graduated lease, basically it's going to be, again, commercials, long-term leases, but the landlord is anticipating inflation. They're anticipating just the cost of living, the economy to go up. So they're gonna allow for these rent increases, just build them in the lease. Year one is X amount, year two, maybe it's 3% more, year three, year five, etc. I think another good example of this might be a startup business. Maybe the lessee is starting a new business, office, let's say. They need an office space. They're not making much money yet, but the anticipation that as their business grows, they can pay more rent. So with the graduated lease, rent increases. With an index lease, rent can increase or decrease. It fluctuates throughout the term of the lease. This is the one that's usually based on some reliable index. Maybe it's the government's cost of living index. Maybe it's the US Consumer's Price Index. But basically what these lease says is that when the cost of living goes up, your rent goes up. Cost of living goes down, your rent goes down. So the landlords, we're signing a 10-year lease. I know the economy is going to fluctuate within those 10 years. So let's allow rent to fluctuate with it.
What type of business would you see this in? Or
Well, it's going to be commercial. So what type of business?
yeah, no commercial, but
Yeah. I
yeah.
don't know. What do you guys think? That's a good question. I guess it could apply to anything, office, retail. You don't like that? You wouldn't sign this lease, I'm guessing.
Well, because no, I wouldn't. I'm just trying to think of a business that would.
Yeah, I am too. What would this commonly be seen? Nothing's jumping out at me.
You can have an index increase with lease language stating not to, you'll have like a cap on it. So maybe not to exceed 3%.
There you go. Because retail, I mean, I don't know. I keep going back to retail because retail is very fluid with the economy, right? When the economy goes up, when cost of living goes up, people are out spending money. So presumably, if people are spending money, you're making more money. So, as Michelle said, you could have this cap on it that says, when the economy goes up and the cost of living goes up, then we're gonna take you not to exceed more than 3% from, what you're paying last year. I think the landlord would want something on the other way too. So when the cost of living goes down and the economy starts tanking, people are out spending less money. So not to exceed less than that 2%. I hear what you're saying, Nabila. There's a lot of uncertainty in this one, isn't there?
Yes,
Because the economy is so fluid.
I'm just gonna Google it. I'm just curious to know.
Yeah, no, good questions. Another type would be a full service lease. The lessor, the landlord, provides utilities, janitorial, maintenance fees. You might have common areas, maybe a hallway, elevator, restrooms. And the lessor maintains this. I think we see this in like large office buildings. If we were face to face, if we were in person right now, we would be in a office building with a full service lease. We had one restroom on the level that everybody on that floor accessed that restroom. There was an elevator, there was a parking lot, there was, one maintenance man for the building or maintenance person for the building. But usually with full service leases, rent's usually a little higher because it's all inclusive. Everything is included, as opposed to the office hiring their own janitorial staff, hiring their own maintenance. So they just have one for the premises that we all chip in and pay for as part of our lease, part of our rent. We may have a ground lease. With a ground lease, these are really long-term leases. With a ground lease, the leasee, the tenant rents the ground. The tenant rents the land. And then they build on it. So they're paying rent each month on the land, or each year, however we agree to that. And then they build their improvement. I've always heard Walmart operates this way. Say what you want to about Walmart, but they're brilliant. They rent the land, they allow you to franchise, but you got to build a Walmart. And not only are they collecting rent on the land, they're also collecting proceeds of your sales happening in your Walmart store. It's genius.
I think
Correct.
Family Dollar is similar to that. They don't own their buildings, they don't own their property, they rent it. So it's easy to see them close down everywhere because there's not really any obligation.
Right, right. Oh, bless you.
Thank
Yep.
you.
Verizon Towers. Man, I wish I had a hunk of land somewhere that Verizon wanted to rent to put their tower on. I wish I did. So yeah, I mean, they build their tower, they maintain it, they do what they need to do, and they just send me a check every month. Again, these are for really long periods of times, and definitely want to get an attorney involved in this, because the lease would need to stipulate what happens to the improvements at the end of the lease term. So if the the lease is for, let's say, I don't know, 20 years, 50 years, I'm making numbers up. And at the end of that term, what happens to the Walmart building? Is Walmart going to buy it? How are we going to handle that? Are we going to sell it to the lessor, to landlord? So that's one really important provision of these leases, and another reason why we need to get an attorney involved, because it needs to be very clear about what happens when it's over. Mineral leases, again, we need to get an attorney involved in this. These are more specialized types of leases. But the tenant can basically rent the land to mine it. One special stipulation of these, any length of time, even if it's for a day, it has got to be in writing. So this kind of breaks our all leases more than 3 years rule. This is what makes this one a little unique. Again, get an attorney involved. So you have this lease, you go in, you mine the land for 10 years. When you're done, you leave. You take your minerals and you leave. You're not buying the land, you're just leasing the rights to the minerals. And another specialized type of lease is for oil and gas. Again, the leasee doesn't own the land, but they're leasing the right to extract from the land. So they go in with their oil wells, use the resource, and then when they're done, the lessor still owns the land. This one is a definite call your attorney, because with this one, there's their separate body of law. There's separate rules and regulations that come with oil and gas leases. Questions on the types of leases? Some common lease provisions. We looked at our pre-printed commercial leases. That's what we looked at together last Sunday. So we're not going to look at those again, but we do just need to make sure that we highlight, that we point out a couple of common lease provisions that you can see in commercial lease transactions. So we're going to go back to our digital manual. And we're going to look in the commercial chapter. We're in the commercial unit or chapter 19, excuse me, chapter 19. I'm going to scroll. And what this list gives us, and I know we glossed over this pretty quickly last weekend, but this just gives us an idea. This says common lease provisions, but just to go through and obviously agreement to the parties and what they need to address. If you're in your hard book, I'm on page 723. You're in the digital, it's in chapter 19. The lessee's intended use of the premises. Why is that important? Why does the lessor care what they do with the land, with the property?
It's possible they have
Yeah.
restricted uses.
Say it again.
They could have restricted uses or exclusives within the tenant mix.
Exactly. They want to make sure the lessor needs to make sure that the lessee's use is allowed. Is it allowed by zoning? Is it allowed by covenants, deed restrictions? For example, if you go to a retail place, they may have exclusivity. For example, so if they say they allow one tenant to come in and open a pizza place, they may say that that's the only tenant that can sell pizza. And if another tenant wants to come in and sell pizza, the first tenant may have those exclusive rights. So why they want to use it, make sure it's in compliance, not just with the laws and the rules, the government, but also with the complex, the community, not the community, the retail center that it's in. Environmental provisions. Again, this is really big with industry, warehousing, kind of manufacturing, anything that's producing, they're going to have waste. And we just need to make sure that their waste is disposed of properly. Repairs or alterations to the premises, not just what the leasee needs to do, but who's going to do it. We need to make sure that we're all in agreement there. Whether or not the leasee has the right to remove fixtures. You may remember trade fixtures. We're going to talk a little bit more about those in just a second. The rights and duties of the parties about keeping the property in good repair, maintaining the property, utilities, insurance, taxes, all that needs to be decided upon. What happens if the property is destroyed? Same thing with residential. There's going to be owner's insurance. There should be renter's insurance. It's going to look different in an industry or a manufacturer than it is a single family home, but everything should be insured. The services that the lessor is going to furnish, what services do they provide? Are there anything prohibited? Assigning or subleasing? We'll talk about that in just a second. The right to renew. Are we going to allow for an automatic renewal, or when it's over, it's over? So that needs to be spelled out. What happens at the termination of the lease? If the lease is terminated because of mishandling or failure of the leasee to perform, how the lessor can address that, how they can handle that. Again, the lessor's right to enter the premises. That's the same thing with residential it is for commercial. There has to be a stipulation saying how that's going to be if and when the landlord's allowed to enter the premises. If the lessee can share the building, if there's going to be other tenants, a multi-tenant, can they do a sublease? We'll talk about that. And then the condition that the leasee would need to leave at the end of the lease. So, just a very basic list, but definitely things that the two are going to want to address in their lease and their negotiations. Everything, this whole list, if you're looking in your book, it goes on page 724. I mean, the whole way over. It talks about these in more detail, but I just wanted to look at the quick list together so we can see those common provisions. And just now going through and pulling out a few, making sure we're good with the terms. So the leasee's proposed use, as we said, the landlord needs to make sure that the property is being used in the legal manner, that there aren't any restrictions. The landlord can restrict, the lessor can restrict the lessee's use. So if it could possibly create an environmental hazard, again, I think of a manufacturing or an industrial. And then competing uses for existing businesses. There's only one pizza place allowed in this strip mall. And once we have a tenant in here or a lessee in here that serves pizza, once we have one, we can't have others. So then when another tenant wants to open a restaurant to serve pizza, that's not allowed. Y'all want pizza now? I think I've said it enough, then I put it in your brain. So what are y'all gonna do for dinner tonight? Probably pizza. It's an easy dinner, isn't it? Another thing that the tenant or the lessee may want to consider is making the lease contingent on the ability to obtain any licensing or zoning amendments or permits. I mean, what if it was a restaurant that intended to serve alcohol, for example? The lessee may want to put a contingency on there. And what's a contingency say? In this case, I will rent your building for X amount under these terms, as long as I can get my alcohol permits, my ABC permits. And that's what a contingency says. I'm not expected to do this until that happens. So that the lessee may want to consider putting some kind of contingency in the lease to make sure they can use the property for what they intend. If they have to do major modifications or build, they may want to put that in for permits. And again, if they're going to use the property for something different than what it's currently zoned for, they may want to have a contingency. I'm not going to rent until I go in front of the zoning board and get this approval, get this permission. If it's a manufacturing, environmental matters may be of importance. The landlord is the owner of the property. So the landlord is going to be responsible for any environmental cleanup. So the landlord is going to want to make sure before the lessee rents the property. That's another reason why we want to know what type of property they are, what kind of waste they're going to have, how they're going to dispose of it. The lessor should have lots of questions, make sure it's handled appropriately. because they're the ones responsible for it. They're the ones on the hook as the owner of record. The landlord could go after the tenant if they disposed of environmental matters improperly. They could go after the tenant. We're going to talk about some of these environmental matters. We'll see these tomorrow morning. So we'll talk about these. And if the tenant or the lessee plans to build, they may want to consider having an environmental site assessment done, maybe part of their property valuation before they lease, before they sign that lease. Make sure that they can use the site, use the land for what they intend. Trade fixtures, lessees trade fixtures are common for retail, for example. Who can remind me, what do we know about trade fixtures and commercial trade fixtures? What do we remember?
That you can remove them?
Yeah, the lessees trade fixtures, they're installing fixtures in the property to conduct their trade. Again, I tend to think retail, restaurants, stores, shelves, racks, that kind of thing. These trade fixtures are personal property of the lessee, of the tenant. So at the end of the lease, unless otherwise stipulated in the lease, at the end of the tenancy, then the lessee should be able to remove their trade fixtures. Now, they'll have to repair any damage to the property that they made installing or removing. They can't just jerk them out of the wall. So they have to repair. And again, North Carolina, this is our special set of fixtures. So unless the lease says otherwise, if they are going to stay at the end of the lease, then the lease needs to be very clear that these trade fixtures are not personal property, that these trade fixtures are going to stay at the end. And if the lessee skips out in the middle of the night, or if they leave their trade fixtures at the end of the lease, then they become real property of the lessor. So they're personal property, the lessee, until left behind, in which case they become real property of the lessor. Remember a couple years ago, we lost a lot of our Rite Aids, and Walgreens was welcoming Rite Aid customers, and Kerr Drugs, and everybody's welcoming Rite Aid customers. Well, there was a Rite Aid here in High Point, and when I drove by it, I noticed when they first closed that there was, what did the sign say? Retail fixtures for sale. So to me, that says that the Rite Aid tenant left their shelves, their racks, their counters, and whomever owned that building. In this case, that Rite Aid ended up becoming a Family Dollar. So I'm sure they could have used it, but maybe they didn't know that, that was going to be, but they were trying to sell those formerly trade fixtures left behind. And now they have those shelvings and racks up for sale. With commercial, also, we've talked about repairs and upfitting. There are no implied promises. If the landlord or the lessor is going to do any upfitting, then we need to decide in the lease what we're going to do, or up to how much amount. Again, we're getting the lessee's place ready for them to occupy it. So usually in commercial, we're starting with a blank slate, and we're going to build from them and get the unit ready for whatever need the lessee has. The landlord does need to make sure that the premises are safe, but they don't have this duty to provide fit and habitable conditions that the residential landlord does. A lot of the repairs in commercial is going to be on the lessee. The landlord just doesn't have the responsibilities. So with no implied promises, everything needs to be spelled out, express agreement, make sure we're all on board, all on the same page. Who is to make any repairs? Well, that's negotiable, isn't it? Is the landlord going to do it? Is the tenant going to do it? And it needs to be stated in the lease how that's going to be addressed. The landlord will typically be responsible for maintaining the common areas, especially if you're in a multi-tenant strip mall, shopping center, office complex. You usually have common areas. Again, upfitting, we mentioned last week, just getting the unit ready for the tenants, the lessee's intended use. The lessor usually provides up to X amount for upfitting costs. Leases may have assignments. So with an assignment, the names of, let me start over. With an assignment, all the terms stay the same. The lease is being assigned to somebody else. So all the terms stay the same. The only thing that changes is the name of one of the parties. So if you're assigning your lease, the new lessee is going to take the lease at the already existing terms. How much, how long? The only thing that would change would be the name of the tenants or the lessee. The assignee is the new tenant. The assignor is the former tenant. With an assignment, who do you think is responsible for the terms of the lease? The assignee or the assignor? The old tenant or the new tenant? We want to venture a guess.
The old tenant?
The old tenant could
Old
still be
tenant.
on the hook if the new tenant fails to perform. So who is responsible? Could be both. You're not completely giving up your rights and obligations. You're just passing them on to somebody else. And if that somebody else doesn't perform, they could also come after the old tenant. Unless that word should be novation. Novation. So unless a novation, with a novation, you're substituting a new lease for an old lease. So if you do a novation, you've released the old tenant from their duties and obligations. The difference in an assignment and a novation. Novation would relieve the old tenant. When they're done, they're done. Let's compare an assignment to a sublease. And a sublease, you're in a sense making a new lease. It's a lease within a lease. Isn't that what we think of with the word sub? It's a lease within a lease. So now the original leasee becomes a sublessor. They are renting to the new leasee, known as the subleasee. Both parties are liable. We're going to do a side-by-side comparison in just a second. Again, a novation would take care of all this. A novation would release the former tenant from their duties and obligations. But even in a sublease, both could still be responsible. Both could still be liable. So in a sense, the tenant is leasing their space. Isn't that something? The big difference in a sublease and an assignment, the sublease can be for less than all of the lease premises. The assignment is for the entire premises. I think where we hear about subleases is maybe a residential lease, maybe for an apartment. Maybe you have multiple people on that lease. You could replace one renter with another. I did this in college. I was on a lease with a girl. We were roommates in an off-campus apartment. And about halfway through the year, I don't know what happened. She went crazy. She got herself in trouble with the law. We had the cops there on a regular basis. She got caught stealing her sorority sister's car. Like I said, we had the cops. We had a couple medical incidences, medical threats. My girl flipped. It was scary. The last run-in with the law that she had, she decided to vacate. She decided to leave. I was thrilled. There were 3 months left on her lease. So we did a sublease. I found another tenant that wasn't in trouble with the law. And she took over. She sublet just her portion of the lease. Mine stayed the same. Does that make sense? That's what we mean by less than the premises. My responsibility stayed the same. She just took over hers. And I had the last 3 months of my lease without, we'll just call it the crazy roommate situation. She stole checks from me. It was an ordeal. We'll leave it at that. I wonder where she is today. Questions on this? The difference, again, the big difference is what part of the premises we're referring to. Sublease. With the sublease, you got multiple people on. Y'all ready for our last break? Let's take our last break. When we come, we'll finish up for the day. And the last thing we do today is going to be what talks about what tomorrow looks like. So before we leave today, we'll break it down and talk to you about what tomorrow. So let's take 10. See, I got 358. We'll come back up 410 again. Any questions, comments? So we got a little bit more to cover, and then we'll talk about what tomorrow looks like. So we are almost 3/4 of the way there. So how's that sound? And most of you are done after tomorrow with post licensing, right? I want to say about half of you were done from what I remember last week. So that's pretty exciting too. Of course, Lane will not report you tomorrow because it's Sunday. And even if she does, the commission's not there to get it, right? So it'll still be Monday before this happens, but we'll talk a little bit more about that as well. Okay. So we're about to wrap up our commercial discussion, which will take us into the very next section, which will get us into tomorrow. Again, talking about just some common provisions found in a lease. The lease renewal, even in a commercial lease, there is no implied right. You know, there's nothing implied, right? Implied means it just happens. Express means you explain the terms. So it's going to be very rare to find implied anything in real estate. And that does include renewing the lease. You can add an automatic renewal as long as the parties agree to it. If you're going to add an automatic renewal, you need to be clear on what does that look like. You know, we both have to agree to extend it for what, another 5 years or however we want to handle that. Preemptive rights are common for commercial leases. You may find these in residential as well. Basically, a preemptive right says that one party, the lessor, has a contractual obligation. If they decide to sell in the future, they're contractually obligated to go to the lessee first. The lessee has this preemptive right. So if the lease provides for it, the lessee could have the first opportunity to purchase or the right of first refusal. Right of first refusal says that in the event the lessor decides to sell at some point in the future, the owner in this case will give the lessee the opportunity to match a bona fide offer. So they have an offer come in from a third party, an offer to purchase from a third party. And before they agree to contract with that third party, they're contractually obligated to go to the lessee first and say, hey, I have an offer for this property for X amount. Can you match it? The first opportunity of purchase, the price has not been determined. We don't know the price. The first opportunity of purchase says, hey, whenever the lessor decides to sell, they have to go to the lessee first, whether or not they have an offer or not. I don't want to sell now, but somewhere in the future, if I ever do decide to sell, I'm contractually obligated to come to you first. The difference in the two, the right of first refusal, you're matching an offer. You already have an offer in your hand and the lessee has the opportunity to match. In either case, how the price is determined, how the two parties are going to determine a purchase price should be included in the lease. You know, we don't really want to agree to a price now because we don't know what the market's going to look like in 10 years, 20 years from now. So maybe we come to an agreement like when we do have the opportunity to purchase, we're going to hire an appraiser. And the appraiser is going to help us determine what that purchase price is. The appraiser will give us the value. So how they determine, maybe they hire a real estate agent to do a BPO. We're a heck of a lot cheaper than an appraiser. So maybe they decide to have an agent do a BPO. Again, it doesn't matter how they come at the price. But they need to decide, they need to agree on how they're going to do that in the provisions of the lease. We've talked about the lessor's right to enter the premises. This applies to residential as well. Unless agreed otherwise, the lessor or the landlord has no right. So was it Sabrina that had the landlord that was stalking her? I mean, was she ringing your doorbell? Was she trying to access the property, or was she just doing creepy drive-bys?
She was just doing creepy drive-bys, and she
Okay,
just did
so-
like at the end. Yeah, no, she never thankfully came on the property.
Right, right. Because that could have been, I mean, that would have been, again, you may not have known that then, you know, but that would have been, you're right. I think this is hard for landlords and lessors. I know when I first rented my condo, you know, I got a little upset. I'm like, I'm the owner of record and you're telling me I can't, it's my property. And you're telling me I can't access it, you know, and on day 2, I was like, my property, I should be able to access if I want to. You know, by day 4, I was over it and I'm cool now. But, you know, that was a hard pill for me to swallow, that it's my property, but I don't have the right to access it. Again, residential and commercial. The reason, or one of the reasons, that the landlord doesn't have the right to access it is because, remember your different types of estates. We're not going to go over them, but there's a leasehold and a freehold estate. And the leasehold estate is the right of possession. So once the owner allows somebody else to possess the property, they lose those rights to possess it themselves. Does that make sense? They're giving up some of their rights. They're giving some of their rights to the tenant or the lessee. I've been in my condo a couple times. We went over once to change the furnace filter. You know, my tenant's perfectly capable of changing the furnace filter, but let's face it, I wanted to put my eyes on the inside. We gave him like 5 days notice. You know, we gave him plenty of time that we were coming. Same thing the next time we went, gave him a couple days notice. Sometimes the owner just wants to put their eyes on the property, make sure it's not tore up, make sure it's not damaged. The tenant or the lessor also has the right of quiet enjoyment. The name is not as it implies. This doesn't mean that, you know, the tenant's not going to get noise from surrounding communities, that they're going to be able to enjoy the property. This is an implied right that we have in real estate. And the lessee has this knowledge that the lessor has good legal title. You don't want the property to be foreclosed on or taken out from under you. And the lessee also deserves to know, part of their right of quiet enjoyment, they also have the right to know that they can use the property uninterrupted continuously. The lessee wants assurance that the lessor is the legal owner of record, that no third party can show up and try to lay claim to the property. It's a warranty of the lessee's leasehold estate. That's what we're telling them with quiet enjoyment. I'm giving you some of my rights as an owner. I'm transferring some of those rights to you. And in return, you have the right to use this unit property without interruption, without interference from third parties. This last little section talks about breach of lease. There's several different. If the lessee fails to pay rent, again, commercial situation, if the lessee fails to pay rent, the lessor can terminate the lease, retake possession of the property. Again, summary ejectment, can't change the locks in commercial. think what makes commercial a little bit different, both tenant and lessee have to pay rent, right? That's their main obligation. That's their main duty, pay rent. What changes with residential commercial is the lessor's rate. Residential, they have to provide fit and habitable conditions. Commercial, they just pretty much need to leave them alone, once they take over and let it pay for itself. But that still doesn't give them the right to enter the property. Again, with the exception of any agreed upon repairs. The lessee can be liable for any waste. So if there's any unreported damage to the property, any major issues, the lessee should still be reporting to the lessor. There's a good example in your book. I'm not going to go the digital, but if you have a manual, I'm on page 731. There's an owner of an office building. And the owner leased the building to the leasee for 10 years. Several years later, the owner defaulted and the bank foreclosed. Is that the example I want? No, I'm sorry, wrong example. Still 10 years. Here we go, 732. That didn't sound right. 732. A lessor leases a warehouse for 10 years. The lease places the responsibility for all maintenance and repairs of the structure on the leasee. So the lease says that the leasee is responsible for repairs, but during the term of the lease, the tenant noticed a termite infestation. And evidently they didn't want to pay for it, so they didn't do anything. So they let these termites eat away. By the time the lease expired, the warehouse had suffered substantial structural damage. In this case, the leasee is guilty because they didn't report to the lessor. They didn't address it, they didn't correct it, they didn't report it, they just ignored it. And so all this damage now caused by those termites could have been prevented, especially if they were the ones on the hook for all repairs, if the lease stated that they were going to be responsible for all repairs. But if nothing else, report that to the landlord. In the event of the lessor's breach, the landlord's breach, the tenant, the lessee could go after them for maybe damage, maybe lost profits if it's a retail and you can't use the premises. And again, the lessee's eviction remedy is constructive eviction. It's not as common in commercial since the landlord, lessor, doesn't have to provide fit and habitable conditions. But if the landlord stops their duties and obligations, they stop doing their responsibility, then the tenant may have a case to evict themselves. Commercial leases are just a lot more per agreement than residential. That's one thing I don't know. I'm kind of I like rules, I like systems. And that's one thing that the Residential Rental Agreement Act gives us that we don't have with commercial. Did I convert anybody? Is anybody ready to do commercial now that we've been through this section? Are you? Cool. There's a lot involved with commercial. There is a lot involved with commercial. So I know this section these sections seem kind of drawn out. None of you told me you want to do commercial. Well, maybe one of you. None of you want to do property management, but it's still just giving us a basic understanding. I know it's hard to get excited about something that you can't apply, something that you don't plan to use every day. But the Real Estate Commission says to cover it, so here we are. Questions, comments, concerns about property management or commercial?
Just concerned about the amount of this that's on the exam.
we're gonna talk, that's what somebody else just said in the chat. So part of what tomorrow is gonna look like is a review for your exam, nod, nod, wink, wink. So, we'll kind of hone in on what you could potentially see on your test. I know we've covered a lot of terms and stuff. And that's why I'm glad we'll have time tomorrow to do a review before your test so we can bring it home, if you will. Again, nod, nod, wink, wink. If you hear what I'm telling you right now, if you hear what I'm saying, then you can breathe and rest assured we'll be all right. We will get you through this. You guys want to know the truth? You want to know my opinion? You know what my opinion means. But honestly, my opinion, I don't think we should have exams in post-licensing. Because to me, it's not a matter of whether or not you can pass the test. It should be a matter of how can you enhance, how can you use this in your day-to-day practice? Now, that's just my opinion. And as I said before, the Real Estate Commission has never, ever called me and asked me what I think. So we have a test tomorrow. But again, it's more important to me that you guys know what you can take from post-licensing to use from your career. So once we get you through tomorrow, all this commercial and property management stuff, you can just kind of throw away. Fair enough?
So I have a question. What happens if you don't pass?
We'll talk about that tomorrow.
Like
you got an option for a retake. We'll let you retake it. Yeah, retake exam.
So the Real Estate Commission says that you have 8. So you do pre-licensing, you take the state exam, and then within 18 months, you have to take an additional 90 hours and you have to pass those too.
Yep. Rephrase that. You have to complete an additional 90 hours. So you have 18 months to pass those 3 tests. That's the completion of the class. Yeah.
Right.
So not just take it, right? Not just show up, but yeah, you gotta, so. Again, post-licensing isn't near as intense as pre.
I'm not gonna imagine.
Oh, you don't know. You didn't do pre here. Never mind. You
But
guys
I know
saw
what
how intense
I know what
pre
my
was.
Yeah, but I had to do 2 exams. I had to do sales agent and broker.
So I guess
Yeah,
we
so
do
you
two.
do
We
two,
do
and
end of
then-
class exam and then the state exam. So you got to get through, you got 2 hurdles to jump here. One to get through the 75-hour pre-licensing class, and then another one for, the commission state exam. So, but we don't do sales associate license here. We're just all brokers. So that's kind
Right.
of one difference.
So it's like a total of 4, and then commercial is kind of a different animal.
Yep.
Yeah.
Same here. Yep. I guess that's one thing about North Carolina. They don't regulate our license, right? Like once they give you a license, they don't say, now, Julie, are you doing residential sales? You know what I'm saying? They don't regulate how I'm using my license. So that's why we have to cover commercial and property management, because back in the day, we'd have 30, 40 people in post-licensing class. So I had a better chance of having a commercial or a property manager, on the smaller the numbers, though. I think the majority of us are doing residential. So we're going to get started on this last section today. We're going to go about, 15, 20 more minutes, and then we'll talk about what tomorrow looks like. So let's get it off of commercial and property management. In this last section, we're just going to come back to North Carolina. And we're going to focus on some miscellaneous North Carolina laws and legal concepts. Kind of hopping around all over the book now, but again, I got page numbers just for reference if you want more information. And then if you're on the digital, this information is on your 303 chapter. So the first little section in miscellaneous law and legal concepts, we're going to talk about some unique North Carolina real property ownership. And you guys are going to be refreshed a little bit on terms like joint tenancy, tenancy by the entirety. But we're not going to do an overall review. We're not teaching this stuff. Again, our focus is going to be, how does joint tenancy look in North Carolina? How does tenancy by the entirety look in North Carolina? So just things specific to our state. So you guys do your head one way or another. Can we as brokers advise a buyer on how they should take title? Can I tell my buyer how to take title? And I see head shaking no, and you guys are right on. So when you're working with, for example, a buyer, an unmarried couple, we're not going to whip out our post-licensing manual and explain to them the difference in joint tenancy and tenancy in common. Is everybody good with that? That's the attorney's job, is to advise people on how to take title. We cannot practice law. And telling anybody how to take title is giving legal advice, even if you know and you have access to the resources. Again, you guys are going to ask. They're going to ask us these questions because we're a heck of a lot cheaper than an attorney. That's our job to know what we can and cannot do, not theirs. Everybody with me? So they ask you, how should I take title? That's on them. So specific to North Carolina, what sets joint tenancy apart in North Carolina? Right of survivorship is not automatic. Right of survivorship has to be intentionally created. So let's back up for a second and refresh what the right of survivorship means. We're going to talk about tenancy by the entirety in just a second. But I think the best way to explain right of survivorship is to consider tenancy by the entirety. Tenancy by the entirety is for married people. Yes, they're married when they take title. And what right of survivorship says, when something happens to one spouse, the property automatically goes to the remaining spouse. Everybody with me? You have a couple that's married, something happens to one. It doesn't matter what this person's will says. Something happens to one. Right of survivorship says the property automatically goes to the surviving spouse. And in North Carolina, it's not automatic. It has to be added. It has to be created.
Oh, sorry.
I heard the aha moment. Joint tenancy typically has equal ownerships. In North Carolina, or equal interest. In North Carolina, you can do unequal ownership interest. You can have unequal interest. Again, it's got to be purposely added. It's got to be created. And that's all the job of the attorney. Tenancy by the entirety, as we just said, is reserved for people who are married when they take title. You have to be married first and then take title. Let's say you're not married, you own property as, I don't care, joint tenants or tenants in common, and then you get married. The act of getting married does not create tenancy by the entirety. You can create it. You could have a quitclaim deed done and create it, but it doesn't happen. So tenancy by the entirety is for married people when they take title. Each spouse owns an equal and undivided interest. They have the equal right to control it, use it, possess it, and profit, receive an income from the property. They cannot draw a line down the middle of the property and say, this is my half and this is your half. You don't come on my half and I won't come on yours. We both have equal right to the property. As we said, it's the default for people who are married at the time of purchase. Does that mean in North Carolina, married couples can only take tenancy by the entirety, take title, tenancy by the entirety? I see head shaking no. Married couples could choose to be joint tenants. They could choose to be tenant in common. Tenancy by the entirety is the default. Again, have an attorney. Help them address why they wouldn't be tenants by the entirety. As we said, anything you own prior to marriage does not automatically convert to tenancy by the entirety. The act of getting married doesn't create tenancy by the entirety. T by E, tenancy by the entirety. And both parties have to agree to sell the property. North Carolina is a spousal state. 1 to buy, 2 to sell. So even if one party buys, both have to sign to convey.
You said 1 to buy, 2 to sell?
Does this include even like if you had the property before you were married?
So if you, that's a good question. So if one spouse owns property before we get married and then we get married, the new spouse would be entitled, it's a marital life estate. So what the marital life estate says is that how much you get depends on how long we were married. So your length of ownership is kind of going to be measured by how long we were married, which you're
So-
entitled.
If you wanted to sell the property that you had when you were single, and you got married, he needs to sign for it as well. Okay.
Yep. The story I heard in pre-licensing, I love this story. The story I heard in pre-licensing is gentleman purchases a condo for his mistress. So he buys his woman, his mistress, a condo. Does he need his wife to buy that condo? How many people can buy? Just one. So he buys a condo for the mistress. That relationship runs its course. He goes to sell the condo. And what's the attorney say? We got to get your wife to sign it. Dude said, what? I'm sure he uttered some 4-letter words. He's probably got some choices now, right? He either fesses up, he rents it. Next time, lease the condo for your mistress or lease the apartment. Don't buy it. I think, Maria, to answer your question, one of my teammates had a buyer a couple years ago, and he was doing that 1031 exchange, the tax deferred exchange that we talked about earlier. And he was the only name on the spouse. The seller was the only name on the spouse, on the deed. He was the only name on the deed. But since he had purchased that property, he had gotten married. So even though she wasn't on the deed, nowhere to be found on the deed, she still had to sign all that closing document to convey the property. Because once they got married, that became, their right. Now, obviously, this doesn't take into consideration things like prenups, stuff like that. This is where we have an attorney involved if there's a prenuptial agreement. How tenancy by the entirety ends. To terminate, it could be mutual agreement. Again, both parties convey the property, both parties sign the deed to convey it. A divorce decree, part of the divorce decree should spell out what happens to the property. Are we going to sell it, split the proceeds? Are we going to do a quit claim deed, transfer the property from us to me, from both to maybe just one? Or death of one of the spouses. So again, that's where our right of survivorship comes in. Questions on tenancy by the entirety? Bottom line, call your attorney. I think in some way, or have your clients call their attorney. I think in some ways we teach you guys in these classes just enough to be dangerous, because now you know how tenancy by the entirety works. And it's really easy when your clients to ask you, how does this work? And we can give them a basic understanding, but if they start getting into lots of questions, we got to get them to an attorney. I had a couple, I was helping them, 2 buyers, they were unmarried. They'd moved down from New York. And I knew they were unmarried, and I knew enough to know that they couldn't do tenants by the entirety. Maybe they were going to get married one day, but they were buying today. So I set up a conference call with our closing attorney and them, and the attorney talked to him on one of their lunch breaks, and they weren't on the phone but 5-6 minutes. And I wasn't part of the call, so I wasn't privy to the conversation. But the attorney had to discuss with them this is what it looks like if you take joint tenancy. This is what it looks like if you take tenancy in common. And even though I wasn't on the call, I'm pretty sure what it came down to was, if something happens to one of you, what do you want to have happen to your interest? Do you want it to go to the remaining partner, or do you want it to go to your heirs? And how they answered that. And they ended up doing joint tenancy with right of survivorship. But that was a discussion they had with the attorney, not their real estate agent. But that's when we need, we constantly are on the lookout for our little red flags. And when a little red flag goes up, we need to be able to say, call the attorney. Questions?
Hopefully your attorney will give you the right answer.
This is why we have
right questions.
Exactly. And to your point, some attorneys are better than others. Yes, some real estate agents are better than others. There's always something better than others. So this is why most of our firms, I know mine does, yours probably does or will, we kind of have a preferred vendor list, people that we've used that we know we've had a good experience with. Our preferred vendor list includes attorneys. It gets updated sometimes. I mean, you have a bad experience with somebody, with a vendor. I mean, simmer down. Everybody has a bad day. Yes, you have a bad day as well. So sometimes you have a bad day, but when they start having bad day after bad day after bad day, when you have more than 1, 2, 3, 4 less than stellar experiences, then it might be time to update your preferred vendor list. Like I said, we update ours about once a year. And honestly, they do an all call. They send a blast email out and says, here's what it looks like. Do you want to add or remove anybody? So, I mean, ours is, truly based on our experience and the good and the bad. Now, with that being said, if let's say I have a bad experience with an attorney, and then I have a buyer that wants to use this attorney. I'm not recommending them, but maybe they know him, maybe it's their cousin and they want to use this attorney. Can I stop them from using that attorney? Absolutely not. It's their attorney. I could say, okay, I have other attorneys on my preferred vendor list, maybe choose from one of these. But bottom line, they're the ones paying for the service. So we need to give them choices and let them decide ultimately who they want to use. Never ever look at a buyer and say, this is the attorney we're using, this is the lender you're using, this is the home inspector. We've got to give them choices. Other questions or comments? Those of you that are in practice, sometimes it's not so much the attorney that makes or break it, it's the paralegal. Let's face it, that's who we're dealing with, right? A lot of times we don't even see the attorney until we're sitting at the settlement. I mean, I've had attorneys before that I've really enjoyed, but the paralegal broke it. Isn't that sad? But that's who we communicate with. And if you ever try to get a paralegal to call you back and you're like pleading, begging, that's a little frustrating, All right, questions? Anybody have anything to say? Anything at all? So this is what tomorrow is going to look like. I got some more to cover. This North Carolina law section, go through some topics. A lot of this is going to be review. There might be a little bit new, but for tomorrow, a lot of it's going to be review from pre-licensing. I'd say for the most part, we've covered everything new. So remember last week, the new stuff last weekend was like firm licensing and the qualifying broker, things like that we didn't know in pre. We certainly expanded more on the property management than the little unit we had in pre-licensing. And then commercial, again, we just don't get into it. So there is some new in this class, but like I said, tomorrow we're going to finish the section and then we're going to do a review. My plan is to finish the section, do a review, take a lunch break. And then when we come back from lunch, we should be ready to give the test and let you guys go. So, and I skipped a piece. We have one more thing to do. So finish this last section, law, special permit, North Carolina, do the review, and then we're going to go over the rules and expectations for my exam. So you may have taken an exam with another instructor at Carolina School of Real Estate. I may or may not do mine the same. I don't know, but I do have certain rules and expectations. So we'll talk about those to make sure we're all on the same page. As you can imagine, I'm not going to tolerate cheating. So I have protocols in place to make sure, hopefully, that doesn't happen. And we'll talk about that tomorrow. And then we'll take our lunch break. And then when we come back in the afternoon, all we'll have to do is that test. And the good news about that is when we're done, we're done. So we won't be all day tomorrow. I can't tell you exactly how long we'll be tomorrow, but we won't be all day. I wouldn't make plans for 2 o'clock or anything if I were you. But just, no, we'll get you done and out of here. Okay.
Can you remind me again how many questions and how long do you have to do the test, or is it untimed?
No, it's a timed exam. The Real Estate Commission gives you an hour and there are 40 questions. So you gotta move. You can't lollygag around, right? You gotta move. But the good news is there is no math. So you won't have to, focus on any of that. And like I said, once we do our review tomorrow, you guys will be good to go.
I don't know why you feel so confident about that. I'm not even, so when we're,
Because I know what the review says.
we don't, I mean, how big's that? I mean, like I've been going through Learn LTP and trying to
Good.
do additional studying, but this is a lot of information.
It is.
So narrowing it down some so we can focus on. Okay.
Nod, wink, wink. I really don't know another way to say that. You with me? Trust the system.
Watch, listen, and remember.
There you go. That's right. That's right. And thank you guys for Nabila for saying that you're going through Learn Test Pass. So remember, hang on really quick. If you guys want something to do tonight, because on a Saturday night, but if you want something to do tonight, if you look in Learn Test Pass, I think one thing that'll help prepare you guys within each section is, I say that.
There should be a quiz for each section.
There should be, that's right,
I was taking one this morning. There, look underneath, keep going down. You see it? Oh, you just passed it.
There it is, I
Right
got you,
there.
thank you, thank you. So each little section has a little quiz, and if you need in Learn Test Pass, reach out to me or, get in Learn Test Pass like today. But this is one thing that'll absolutely help prepare you for exam tomorrow. Not so much the material, but getting you guys in practice. I mean, of reading these dang test questions and the answers, right? Interpreting them. But one thing I like a whole lot about Learn Test Pass, and not only does it give you the question and the answers, but it also tells you why this is right or wrong. And to me, that is more helpful, or just as helpful, I should say, is going through. So I would go through these, and I mean, there's, 20 questions in this one, a couple questions here, 10 here. So I would go through these tonight and first thing in the morning, just to help prepare you getting in practice of reading those questions. Anything else? Everybody good?
What score do we have to get, Julie? Is it
75%.
75? Okay.
Yep. 75%. I think you can miss.
3.
You can miss 10, so.
Who's that 3?
Do what?
You keep say 3, you can only miss 3 questions.
I'm just Tease.
Oh. Keith's having fun up there.
You got it under control.
All right, guys. We'll see you. We'll get started right at 9 o'clock tomorrow morning and knock out what we got to do and be good. So you guys have a good evening. Look over this stuff. Learn to pass. That's why I direct you guys. That's what I think is best. And we'll take care of this tomorrow.
All right. Thanks,
Sound
Jill.
good? All
Okay.
right. Y'all have a
Bye-bye.
good night.
Bye-bye.
Bye-bye. Good night.